Good morning, Jai Jagan.
Jai Jagan.
Yes.
I am the assistant to my matter out of list, your lordship. In a case, your lordship has specifically directed the appellate authority collector to dispose of a caste matter regarding a child minor admission in the school. That he has decided, my lord, while deciding, not only he has cancelled the order of the your lordship, my order, child minor order, also the caste certificate of the father also cancelled, which he doesn't have jurisdiction at all, as per the statute. Your lordship, his job may be taken. Lordship, tomorrow.
My lord, this is the first matter, my lord. Regarding issuance of guardianship certificate, father has already made since 2020.
Airship certificate.
Guardianship certificate. First matter, kindly taken over tomorrow.
Any urgency?
Urgency, the father has given it 20 years.
Take all, take back.
Very urgent, your lordship. My lord, very urgent, my lord, kindly taken tomorrow.
Put all matters.
Transfer matter, your lordship.
Transfer matter. Take all matters. Post them tomorrow.
Also, I know
Festival is coming.
some matters from the default of yesterday.
We have decided not to object harshly.
Also, item 57.
Many youngsters will be there.
My lord, yes.
The holidays are coming.
Holidays.
Festival is there waiting. Maybe they need something to tell to their clients.
Also, item 57. This matter, also Monday had this matter. It is a matter related to extension of time, question of clarity. This is a gazette notification for restraining the dealer of explosive to sell the explosive item in the local market. That central government gazette notification. So far, the oil corporation company is concerned, the government of Union of India extended the time till 30th September.
For you, they have not done that.
Not done. That's why Lordship specifically directed to take instruction posted this matter today. The item 57, if not, it's just taken up today.
We will try it because all their crackers.
Why dealers?
No, it's under the Explosives Act because of what reason? Anyway, when it reaches, you can argue. Wait,
Yes.
you just mention it around 12:40.
Yes.
I may pardon your lordship. Item 21, your lordship. I prefer after vacation,
You want after vacation?
my lord.
Your lordship, item 48.
Inform your friend also.
State.
State is always your friend or always your enemy. Don't worry.
Lordship, on behalf of the appellant for item number 48.
48?
Yes. It is a 2025 matter. I pray for an adjournment.
You want 21 matter, you want adjournment?
25 matter.
25 matter?
Yes.
First week of November.
Much obliged.
Item 1. The petitioner in his application challenged the order dated 23/12/21 melody
Are you arguing or whispering?
in which the opposite party has
Assistance of your mind.
rejected the representation disallowing the
What?
retrospective promotion. Yes, my lord. From the date,
My lord, it was a notice be issued, but here rejection is at annexure 10.
Yeah. That appears to be contrary to law.
Yes, my lord, 2009 he has retired. Lordship may issue notice.
That's fine.
Because 30.
Mr. G, President ATA requested to accept notice for OPs. Okay.
item 2.
Budget matters
Ah.
kindly be added.
Similar matters. Interim order is granted.
No interim order.
Notice is ordered. Notice is ordered.
Notices.
Okay. Only
Yes.
Mr. G will argue.
Give it with me.
Okay. Call along.
Item 3.
Item 3, may I please, your lordships? Your lordship, these are regarding...
You have come to court now.
Yes.
Otherwise, you were arguing online.
Yes, your lordship.
Anyway.
Your lordship, the first two matters are regarding the grant of RSCP benefit, your lordship.
We have already
Similar matters.
noticed, na?
Yes, your
Yeah,
lordship.
give that.
But the third matter is regarding the grant of benefit of UGC pay, your lordship.
Third matter.
Also, similar matters have been
Call along with, call along with.
This is only the third matter.
All right. Yeah.
Item 4.
Obliged, Your Worship.
May it please your lordship, I am the petitioner and I have actually filed one case before the executive magistrate Kendrapada since
Case 89 of 23. It's not being disposed of.
not yet disposed of, and I have sought a
Direction. Before whom it is executive magistrate means which OP?
OP number OP number 1,
OP number 1, sub-collector.
sub-collector.
Mr. G will direct them to consider and expeditiously dispose of. If it is still pending.
My lord, lordship may direct, but there is a seeking prevention of pollution, which rice mill is creating
They
pollution.
have appealed, and that should be disposed of with
Yeah.
representation.
Lordship may direct, kindly.
Obliged.
Short grievance, short grievance of the petitioner is aired in the prayer column, which has the following text. First one, next paragraph. Learned counsel for the petitioner submits, and this court agrees with that. His case number 89 of 2023 relating to pollution could not have been kept long pending.
84, my lord.
23, 89 of 23.
84, my lord. That has been
It wrongly mentioned. But you rectify that.
In annexure, it is clearly mentioned that it is 84.
84, not 89. But you rectify that prayer. Pending. What you have written? Could not have been kept pending. Pending, long pending. First down. Next paragraph. Learned AGA on request appearing for the AGs, the OPs, very fairly submits that to instruct OP number 1 to take a call in the matter at the earliest and in any event within a period of 4 months. 4 months. If all contentions are kept.
By opposite party number 1.
1. 2 will say no notice need be given.
No, 2 is another rice mill.
Correct.
They are
Maybe your opponent. 2 is
My
opponent.
opponent.
First one. This is appreciable. Next one. In view of the above, the petition is disposed of without expressing anything on merits of the matter. Keeping open all contentions of parties. First, since no effective order is passed adverse to the interest of second respondent OP, notice to it is dispensed. First off, registry to send a copy of this order to OP number 2. Okay.
Item 5.
Item number 5.
Yeah.
Lordship may kindly have a look to the prayer. Prayer is.
So,
Wait a minute. Prayer is second prayer. Direct the opposite party number 1 and 2 to implement the order passed in GIA case number so and so within 1 month. Not 26 years is not getting justice. First one is education is sought for a direction for disposal of the execution case which is pending. Twofold it is.
which one? Page number 5.
Page number 10, your lordship may kindly see. Page number 10, it is prayed
Page
that.
number 5.
Yes.
Yeah, prayer is.
No, sorry. I'm sorry. I'm holding 6. I'm holding 6.
Number 20, GPA protecting the name of the AC.
I'm
Who is the opponent in this case? OP. Go to the first vehicle. Postmaster. Knowledge. Issue emergent notice. Learned VST is requested to accept notice for OP number 1. Okay. Call immediately after service. You serve a copy of that petition on VST. Okay.
My name is recorded.
Is for the opposite parties for the ISGI.
You are yes, see,
Senior penal counsel.
is requested to accept notice for OP number 1. Number 1. Emergent notice to OP number 2. Post immediately after service. Okay.
Item 6.
May I please, your lordship?
Yeah.
A peculiar case, 26 years I am fighting, your lordship. And your lordship will astonish that the State Education Tribunal is afraid of the government officers. For that reason, this execution case pending, last 5 years is not passing any order.
We tell them to execute.
Saying that, for that entire order sheet I have annexed it, that is annexed.
No, I am agreeing with you. Still you want to argue?
Oblige, your lordship. If your lordship wants, one day the order will be executed. I know. I have that confidence and faith, your lordship.
The short grievance of the petitioner is as to long pendency of his GIA case number 10 of 2018, correct?
My lord.
Which arose out of an order made in OJC number 4932 of 1999 by this court. Learned counsel for the petitioner vehemently argues that even the despite the confirmation of the said order, despite confirmation of the said order by this court by the FAO number 508 of 2020 disposed of on 7/2/2023, things have not changed, have not undergone any change, and not even a leaf is turned in his case. First off, he cites a decision of Apex Court in Rahul Shah. Okay. Next paragraph. Learned counsel Mr. AGA Mr. G points out that the tribunal is a singular body for an entire state, and that it has the mounting workload on its shoulder, and therefore some delay perhaps has occurred in the matter. First off, he agrees with the suggestion of this court that in the light of Rahul Shah, the execution needs to be tried and disposed of within an outer limit of 6 months. 6 months. First off, next paragraph. Ordered accordingly, and writ petition is disposed of, keeping open all contentions of the parties.
Less time because he is retired.
6 months.
In the meantime, he has already been retired. And during 26 years of fighting of litigation, he has also been given retirement by attending.
About the counsel for the petitioner also tells the court that his client has already retired without getting the benefit of the order. Next.
Since your lordship issued notice with regard to the fixation of date of entry into the service, date of seniority, they have changed the unilaterally.
Yes, emergent notice. All along with the WP numbers.
26645 up to 225.
Immediately after vacation. In the 3rd week of October.
No, that case is posted to last week of October.
All along with the signs. So don't fix the date. Otherwise, there may be conflict. Yeah.
Item 8.
8 not. Here I am challenging an order of cancellation of the allotment of the property of the petitioner. That is under annexer, the last one. Kindly have a glance.
Yesterday you mentioned?
Yes. Annexer 9, page 40.
Issue emergent notice. AGA for 1 and 3. 1 and 3. The emergent notice to other. First up, an application in IA number 14659 of 2025, supported by affidavit says, filed seeking reprieve at the hand of his court during the pendency of expressing apprehension that the petitioner would be put to great injustice and hardship if impugned proceedings are not stayed. Personal, there is force in this submission. Next paragraph. In the above circumstances, application having been favored, impugned order is stayed till the next stage of hearing.
Item 9.
Matters related to MSCB after completion of 30 years service, my lord.
Our judgment.
Yes, ma'am.
Yes.
All matters, my lord.
All matters are covered. You have changed all the date. One order will do.
I have rounded off. According to my petition, that will be installed one.
Same.
Item 10.
Yes.
This is an equal pay for equal work matter, and the order, similar order has already been passed.
You have changed the date also now?
Yes.
Yes.
Obliged.
Yes.
Item 11.
My lord, since 94, lecture 1, page 18, I have been continuing as laboratory attendant in the faculty of zoology, my lord. Page 18, the engagement order issued by the governing body. Since 94, uninterruptedly, I am discharging duty in said faculty. But my status and designation was changed by the director, page 56, only on accepting the submission of the governing body.
I have seen people using the specs for seeing, but you are removing sealing papers. It's a strange case. As strange as your case is. I have changed the status.
Yes, my status is being changed, page 56, accepting the only submission of the governing body. Page 56, second para. The principal in charge, secretary on behalf of the governing body, has submitted that the present petitioner has never been appointed against the post of laboratory attendant.
This is said when?
My lord?
This is said when?
Page in the yes, my lord. In the year 17.
17.
Yes.
Perhaps some brother needs water. Do you have water in the court? Go and bring water. Yes.
My lord. Earlier I was approaching and the director
Director of Higher Education.
Higher Education. Higher Education. Page 56, second para. The director is...
Accept me. Take notice. It requires consideration in the light of my order which I gave last month. Last month.
Yes.
King of status. Because of Tulsi Ram Patel or Union.
My lords, here the thing is different, my lords. He has not made party to the affected party. There is
not claiming because I am in the path of retirement. She has the...
But them you are not worried about this one? Yes.
no, my lords. There is interstate dispute between the parties.
But
regarding in respect of the same post.
He may get because it is the lookout of
that is
government because he has manipulated document.
Anyway, you can take up a contention for dismissal of the petition on the grounds that necessary party is.
My lord.
At the time account.
Instead of that, the best way is to make him a party. You need not make application. I will direct you to make him a party. With that, you make it. That helps you. Otherwise, again, on that ground, if petition is dismissed, get the baggage. That's the great injustice to your client. Petitioner has moved an oral application for impleadment of a party, arguably who is a necessary one, if not arguably with the proper party, if not necessary one in the light of decision of Ex-parte in Rajia Begum versus so and so 58 Supreme Court. First time. In matters like this, and the case is at the admission stage, the prayer cannot be denied. And no prejudice will be caused to anyone, except that the cost cycle becomes a little longer by additional but first. In view of that, permission as sought for is granted, and the petitioner is petitioner to add on that add
yes,
the said person as OP number.
OP number, my lord.
OP number for first one. Issue number 10 notice. Learned AG accepts notice for 1, 2, 3. And emergent notice to 4. Just find out this.
Item 12.
May pray because since 94.
But this order is made when?
No, not this particular date after vacation. But that I was.
First, immediately after service. I have rendered one judgment in the keeping in view Tulsiram Patel. Just look into which is that judgment. Maybe our Samal Sahab will take that. This vacation he will write a book on law of education and law of service. Yes. Take that one. Bring.
Please. May I please, Your Lordship?
Yes.
This matter, my lord, husband not included his wife's name in the pension paper during the time of his superannuation, my lord. The present opposite party number 7 is the husband, my lord, and present petitioner is the wife. Husband working as a teacher in the high school, my lord, and during time of his superannuation, is not included the petitioner's name in the pension paper because, my lord, there was a
slowly. There should be full stop, comma, etc. There are speed. How many kilometers away your house is from our High Court? No speed breakers. No speed breakers up to your house.
Speed breaker
Anyway, a name you take. I have written one judgment on identical point in Karnataka when I was in Dharwad bench. Okay, that supports you. Now I will issue notice. You look into that judgment. It was under Karnataka Civil Services rules. All right. Husband is bound to mention name of the spouse. That's how I have held. Just look into that judgment and come back next time. Okay. So emergent notice. AGA is requested to accept notice for 1, 2, 3, 4, 5. First time. Emergent notice to 6 and 7. Husband is not in good terms with you.
No, my lord.
Okay.
At the time of his
still you may have a right. Yes. Yes.
Item 13.
Petitioner is a primary school teacher, my lord.
Yeah.
Who became ill, but after that she was medically fit, my lord. But
how long you were away from service?
I was away from 1998 to 2004. Thereafter, my lord, the medical board has already medical fitness certificate.
The presentation is considered. You will be happy.
I think within a stipulated time because you will
That's
Annex 13 and 14.
13, 14.
Commissioner cum secretary and director. 1 and 2, my lord.
Petitioner has made 2 representations dated 19/6/2025 and another is
22/8/2025.
22/8/2025, wherein she has sought for reinstatement in service.
No disciplinary action was initiated. She was not terminated. She has
sought for that.
resumption
Your
of
representation says reinstatement in service.
resumption of duty.
Service as assistant teacher in elementary school. First, Learned Counsel for the petitioner submits that although the representations are not happily worded, the actual relief which his client wants is a direction to permit her to work as a teacher in as much as at no point of time she has been removed from employment. First off, he also tells that if a direction is given to consider the subject representations in a time-bound way, his client will be satisfied. First off, next paragraph. Learned the AGA.
My lords, she is not in service since 1998.
My lord, whatever. Learned AGA appearing for the on request appearing for the OPs opposes the petition, saying that since decades the petitioner has not been in service, and that can be a case of abandonment of service, which would bring the vinculum juris to an end, and therefore interference of the court is not warranted. First off. He also, having so contended, now he agrees with the suggestion of this court that the subject representation should meet their fate at the hands of jurisdictional authority, namely
Commissioner comes secretary, OP number 1, and director elementary education, OP number 2.
How two persons will take decision? Any one
Commissioner comes secretary, OP number 1.
OP number 1 stroke 2.
Is competent.
In accordance with the law. If a reasonable time is fixed and all contentions of the person are kept. First, this gesture from the state is appreciable. Next paragraph. In the above circumstances, petition is disposed of 8 weeks. Within 8 weeks, they have to consider.
My lords, in fact, the DO is the competent authority.
DO and of OP 1-2, jurisdictional OPs.
Commissioner has directed the DO and BO to inquire into the matter in Annex 4.
Keeping in view, which is that?
Commissioner, DO and BO.
He directed inquiry now. He inquired.
Annex 14. Annex 14.
Annex 14.
Annex 14. The DO and BO have to inquire into the matter urgently. DO is opposite party number.
No,
DO is 5, BO is 3.
Where is that communication?
That communication is in
Body of the.
In terms of who gave the commissioner gave that?
Yes.
In terms of commissioner's letter dated
22/8/25, same date.
22.
On the body of letter representation, he has endorsed to
That
there is no
In
specific.
terms of endorsement of commissioner dated the 22/8/2025.
Yes.
Correct. Found on annexure representation, second representation at annexure 14. Okay. Next. Item 14? Yes.
Within time, which time?
8 weeks. 8 weeks. Open to public information, document, etc.
So the petitioner is a primary school teacher. He was made to retire on attaining the age of superannuation on 30th of April 2013. Since the retiree dues were not released, he approached the Law and Tribunal, and ultimately that application came for adjudication before this Honourable Court. Your Lordship may have a look to Annexure 2.
But it said, I believe you.
This Honourable Court said that since they raised that was the proceeding initiated, that has been since dropped, they directed that the retiree dues are to be given within 3 weeks.
Where is that order?
Yes, my lord. Your Lordship can have a look to page 20. Paragraph 7. In view of the order, clear order passed by the Law and Tribunal under Annexure 1, the court, while holding the proceeding initiated against the petitioner,
With 18% interest.
my lord,
With 18% interest.
that was dropped.
18% interest. That is paragraph, you are reading that now.
Page 20.
Page 20, paragraph 5. It mentions
Paragraph 7, my lord.
That's what.
Paragraph 7, the directions of the Honourable Court. In view of the clear order passed by the Law and Tribunal under Annexure 1, this court, while holding the proceeding initiated against the petitioner to have been dropped, directs the opposite parties to release all the retirement benefits as due and admissible within a period of 3 months from the date of receipt of this order. One minute, ma'am. The problem level ends here. After getting this order, the provisional pension was released in favor of the petitioner from the date of retirement till April 2024. Suddenly a letter was communicated to the petitioner, Annexure 3 at page 22.
Saying,
For submission of non-engagement certificate in office from May 2024 till date,
I am a retired person, my lord. What non-engagement certificate? For which my lord, my provisional pension has been dropped. I need non-engagement certificate is only given when the person is placed under suspension. A new concept has come to the mind of the DEO. I do not understand.
DEO appears to be very creative minded person.
And minus from May 2024 till today.
If you permit, we will issue.
Yes.
Yeah. Mr. Behera is requested to accept the emergent notice for all OPs. Call this matter in the last week of October 2025, since this is a second round of litigation and the petitioner is in the evening of his life after retirement.
Item 15. Direct for releasing the provisional pension from May 2021. I am not getting it.
We will do it in October. It's main matter itself. Main matter itself we will do in October.
But let me survive. I am a retired over 7 years. I am depending on the provisional pension. I have been getting it. I mean, that's the idea, my lord.
No, that amounts to virtually
allowing the repetition.
You committed wrong and you said that you are allowing the repetition. I don't understand, man. Let me survive first. I have been getting it.
Let us see the immediately after vacation. I post this matter immediately after vacation. Okay.
Can I pray for a date, my lord? Because on 8th, my lords are sitting. Can it be on 8th or 9th?
On 15th, we will have. Okay. 15th.
Item 15.
Please, your lords. I am Gopal Chandra Das. I am the counsel for the petitioner in this case. My lords, I have been instructed according to the roster notification that this matter is the assignment of Honorable Justice A.C. Behera.
Post this matter before the roster bench after verifying the factuals. Okay.
Mobilized, your lordship.
Item 16.
Maybe. The petitioner is working as a laboratory attendant in biology in an aided institution since 1993 onwards. And now initially the post of laboratory attendant was not admissible to be under the GIA fold. And in the 2016 only, page 22, 9/4/16, the government have amended the yardstick and the laboratory attendant post was eligible to be approved for receipt of block grant. Page 22, madam. Page 22.
Post of para 5.
Para 5, already inserted.
Yeah.
Based on that, the college authority submitted proposal annexure 5 in favor of the petition along with other laboratory attendant holding our other post. Now, annexure 6, 2021, page 28. The other laboratory attendant physics, chemistry, and education
persons are approved.
Yes, physics, chemistry, no man. And thereafter already there are several correspondence. All the formalities are completed. And principal time and again page 37 last recommendation 15/125 to the director to approve my service. Till date, the OP number 2 is sitting over the matter. I have already
Direct the OP number 2 to take the
yes. Annexure 10 I also have given a reprint.
Annexure 10 is there.
10.
Page 38.
Go to petitioner is ventilating the grievance as to non-approval of her services against his services against the post of laboratory attendant in biology as per the EIA Amendment Order 2016. First answer. Learned counsel for the petitioner draws attention to Annexure 5, wherein 3 of his colleagues have got
Annexure 6.
Annexure 6 dated
3/2/2021.
3/2/2021, wherein 3 of his colleagues have got the approval, whereas his client has been given stepmotherly treatment, despite all papers being submitted from the side of the institution. First, counsel draws attention of the court to the representation dated 7/4/2025 at Annexure 10 made in this regard. First off, he tells that unless the court intervened, papers would not move. First off. Next paragraph. Learned AGA Mr. Mohanty, on request appearing for the OP numbers 1, 2, 3 and 1 to 4.
Yes.
1 to 4. Opposes the petition contending that in the matter of approval, a host of factors enter the frame, and therefore no direction can be issued for granting approval. First off, however, he agrees with the suggestion of this court that he would instruct OP number 2 to take a call in the matter, looking into the paper submitted by the institution sponsoring the case of petitioner for approval in a time-bound way if all contentions are kept to. First, with this stand, counsel for the petitioner contends. First, next, in the above circumstances, 8 weeks open to solicit information, etc., etc. No. Consideration should take place in the light of amended GI
order 2016. The amended yardstick.
Amended
yardstick of 2016.
Not amended GIA.
Amended yardstick appended to GI order 2008.
Keeping in view the amendment to the
GI order
yardstick, GIA yardstick.
GI yardstick 2008.
Yardstick dated.
The amendment is 9/4/16.
No. Yes, you are right. Of 2016. A copy you are not produced.
Yes, amendment copy I have the extract, Annexer 4. The entire yardstick.
Then, next.
Item 17.
May I please, Lord, sir?
Yes.
In this case, when the petitioner is continuing with the transfer basis in the police high school, Alcala, they have not extended the benefit of taken over high school employees of government employees as well as
implement the order of the tribunal.
My lord.
What the tribunal said?
Tribunal said to consider the case representation in Annexer 6, my lord, page 44, and regularize her service with effect from their resolution under Annexer 2. But thereafter they are not complied with. I file a writ application before this Honorable Court. After the order of the Honorable Tribunal, Annexer 7 series was issued by the Director Secondary Education Odisha, intimating to this Secretary to consider the case of the petitioner and issue a suitable instruction basing upon the resolution that under Annexer 2. Thereafter, they have not complied with. The petitioner filed a writ application before your lordship. This is the Honorable High Court, my lord, disposed of the same on 11/2/2020, paragraph 2 and 3.
Page
51. Paragraph, law and counsel for the petitioner submit that in pursuance of the order of the order dated 2/12/18, passed in way number 2399C of 18, the Director Secondary Education Odisha by his letters number 13/3/19 and 25/4/19 has already forwarded to necessary instructions. Thereafter, they have not complied with this order. Petitioner filed a contempt application. Contempt application disposed of with a direction to comply the order within 1 month. The page 54, my lord,
that is not being.
That is not being complied with. You will also direct to comply the petition in the retired, my lord.
No, if I direct again, they will keep it in cold storage. We will haul them up. Why that has not been considered?
Yes, sir. You will direct.
Issue emergent notice. Direction. There is a plethora of directions now. Tribunal has directed, coordinate bench has directed.
Then contempt also.
Contempt is direction. But it is not, they don't care about a direction.
So you will also direct 2 weeks or 4 weeks.
Direction. That again you will.
After you will also they have complied with. You have to dispose of the matter.
Yes, let that notice be issued and counter be filed because with the disposal is 2020 million.
20. I may impose 1 lakh rupees cost for making him to approach the court, tribunal several times.
My lord, let us file the counter.
File counter. This is fit. I was waiting for such a case. Yes. Issue emergent notice. DGA Mr. Mundi accepts notice for OPs. Since the direction of this court, the coordinate bench of this court, and the direction of Odisha Administrative Tribunal in OA number 2399 of 2018, and also the order made in the contempt. What is that case?
CONPC number 5352, page 454.
So and so have not been complied with, some stringent action needs to be taken, says counsel for the petitioner. First, there is a ring of truth in this matter, and therefore it needs to be viewed very seriously. Unless on the next date of hearing, the compliance is reported to this court. Okay.
Notice a copy to the
Yes, you have to serve copies, na? Registry to share a copy of this order with learned AGs.
Item 18. My lord, in this second round to read, the petitioner seeks to challenge the order of rejection of her claim.
What's this matter in the last week of October? Last day of October. Okay. In the meanwhile, if they do, then everything will be all right. I was waiting for such a case to come before me. Yes.
The petitioner seeks to challenge the order of rejection of her claim or her regularization of her service. My lord, the petitioner performs core functions meant for the physical and mental development of the special group of learners who belong to downtrodden and vulnerable sections like the SC/ST community. And the petitioner is integral to the institutional operation, my lord, which is permanent in nature. And the service of petitioner is also perennial in nature, my lord. And I am not through any black door policy, my lord. Principles of equality opportunity has been followed.
Will issue notice if you permit me?
Yes,
the impugned order is at annexer
I saw
6.
that.
Notice which.
I want that notice. Or the GA only accepts notice for all respondents. Item 9. Call in the first week of November. Okay.
Item 19.
Well, the petitioner is a primary school teacher. He faced a major road accident in the year 2018. His ribs and right legs were broken, my lord. In the right leg, the one portion, my lord, the support is given by...
Read your prayer.
Prayer to make me transfer to the Bhubaneswar block or where I can get the treatment, my lord.
You want transfer?
Pardon, my lord.
Where are the accident papers?
Accident papers, my lord. The annexure.
What accident it was?
I was moving by a bike.
Vehicular accident.
Vehicular accident, my lord.
Any claim petition was made by the tribunal?
Yes, my lord. Claim.
Any compensation is given? How much compensation is given?
I have not taken instruction. He has received the compensation. My lord, what is the condition now, my lord? He has been posted in a hilly area.
Where we want to know what is the extent of disability. What 60% disfigured or affected?
60%. 60% that I have annexed the disability certificate.
60%.
Yes.
Disability certificates for paying compensation are they are different class. But for
what is the present condition, my lord? What happened? Now this has been right leg became septic, and the pus are oozing out from the right leg, my lord. I have seen. He had come. I have seen that the pant of his trouser of that petitioner became, my lord, white due to pus, my lord. That is at the stage of even amputation is required, my lord, because I saw that it can't be cured.
But you advise him to go for amputation.
No,
because you are not the medical doctor.
My lord, now I prayed, my lord, for transfer me to the Bhubaneswar block from Banpur block, that the inter-district transfer of the Khurda district. I applied for that. They did not transfer me. On the other hand, my lord, they have transferred 19 persons to the inter-district transfer, my lord. Yeah, annexure 16.
Do you have photographed your client's injury?
Injury, my lord. At present, I have the prescription order annexure 15, my lord. present prescription.
You are presently
Working as the assistant teacher in level 5A in the school, my lord.
Where is the certificate which recommends such a claim?
My lord, that is there, my lord, such a claim I am making.
What? In the place where you are working?
Khordha district.
Khordha district. I have been posted in a remote area, hill area in Banpur near the Barbara forest.
I have not asked the question.
My lord.
You should permit me to complete my sentence.
Yes, my lord.
In the place where you are working, now on transfer,
yes.
Whether in that place medicine is not available, medication is not available.
No, not available.
Is it true what members of the
Yes.
This is not far away from Bhubaneswar. It's all the way, it is in the district of Khordha.
How many kilometers?
It is around 20 kilometers because Khordha district, it is under the Bhubaneswar.
Say, my lord, it is more than 80 kilometers away from the district headquarters.
Go to Google.
80 kilometers.
Ask Google how many kilometers.
Banpur block, the remote area, Barbara forest park. I am giving that Google.
Just see, can anyone help? Just see that. Google distance, road
by road.
Not by helicopter.
Road by road. That is the school. I am giving my notes. That is Procedural in this Laktipoda. I am giving my notes. Immediately.
It must be somewhere between you and Mohanty.
Both are we are Mohanty.
He is the man of Bantu.
83 kilometers.
83 kilometers.
But IMI submitted that. No conveyance is there, my lord. No transport facility.
Hey, Mr. Mohanty, you have transferred other people. Why not this poor fellow?
I am unable to work.
I'm conscious, my lord. It's not a matter of right, but keeping in view his submission so far the indigent condition.
Yeah. Our constitution does not prohibit compassion. It does not say nobody shall be compassionate to anybody. On the other hand, our preambular statement is fraternity. In that, everything will fall. We should treat everybody as brother and sister. Fraternity, Ratrutva.
I require immediate treatment at Bhubaneswar by specialist.
Or at least till consideration of this.
No, that I mean they have.
Now they are saying that they have not on transport. Transport order is not under challenge. They seek the relief of.
They need the transfer. Because MEC case happened.
Can they file the representation?
They have filed, that will not help.
My lord, this is not there.
That has been rejected earlier.
Much earlier, but keeping in view today's position.
Rejected.
Along with the medical.
64 you are given earlier.
That was rejected, my lord.
Even now that injury continues.
Now it become fatal, my lord. I have seen in my own eye, my lord. It become fatal, my lord. He is unable to walk, my lord.
But how can he take class?
My lord, he is unable, my lord. You are taken by the vehicle and he was kept there near that retreat on the hilly area, my lord. That family members.
I'll call this matter tomorrow. Do something in this.
Tomorrow.
Because
there is no other working day also after tomorrow.
That is the reason. Requested to accept notice for OPs first. Because of the acute ailment which petitioner has suffered in a vehicular accident, he needs medical treatment at Bhubaneswar. And traveling from the present place is obviously very difficult. Therefore, learned AG is requested to do something on a war footing in a matter like this, so that the word fraternity appearing in the preamble of the Constitution of India will have some meaning. First off, I'll call this matter tomorrow. With registry to share a carbon copy of the order with the learned AG. Yes. Tomorrow.
Item 20. May I please, Your Lordship?
Yes, sir.
His cell deed was presented for registration on 28th July 2025.
28th July
2025.
2025.
Yes, my lord. The opposite part number 7, Jasoda Sahu is the vendor and my client is the vendee, the petitioner certificate. It was, the slot was allotted to me by the sub-register. Both of us presented before the sub-register. It was registered. My LTI was obtained. My photograph was taken. Everything was, it was checked. Everything was correct. And cell deed was also completed. But thereafter, for the reasons best known to the sub-register, they are not delivering the cell deed to us. That is the only predicament. And although there is a notification of the state government or revenue department that we have to register, the sub-register is bound to register it on the day when the same was presented and return the original document within 3 days. That is the notification of IGR. So only my prayer is.
But or else you not may direct the opposite party number 5 to take action. If there is no other impediment.
Yes, that
I do not know why.
So once we put if and but, then they will extract money from the citizens.
Notification, Your Lordship can see the notification also.
I have been here in your state since the last 4 or 5 months. Once we give, consider this, etc. It is not that everything will happen unless some grease is put on the farm.
Normally they don't delay. But why in the particular case?
My lord, it will only, my responsible submission is that Your Lordship may direct that if the registration is completed in view of the notification of the state government, it may be handed original, may be handed over. If the registration is completed, that will, Your Lordship may kindly
see. You made OP number 6. Private party,
that is pro forma. That is my vendor. We are selling in same boat. He sees the vendor and the vendee. Both of us have common interest. I can delete her also by giving a memo now, just now. I have not claimed any relief against him.
Sure.
And one more thing, whether this matter, Your Lordship,
before this court.
Yes, that
comes before me. Registration. This is a registration is a general. I am a general miscellaneous. All general miscellaneous is with me. Residuary matters. All residuary matters which are not with any judge are with me.
Then Your Lordship, I have to verify.
It's a residuary court.
Yes.
Then Your Lordship.
And many times I feel it is a small cause court also. Kind of the matters they come.
Sir, Your Lordship,
behind every cause there is a man.
Yes.
I should try.
Your Lordship may kindly have a glance. Your Lordship may kindly have a glance to this government notification.
Why can't you enjoy some humor? You are not taught all this.
No, like sorry.
Resistive temptation. Something is going on.
I'm sorry.
See, if we put if and but, then what is happening in the government offices, we judges know. We know. You also know. I know that you know.
Why they are not giving it to me, that I cannot express in words.
Telling that only they kindly be seated. Basanto, you are disturbing. Basanto, you are coming in the way of granting relief to your client. That's not the way of advocacy. Yes. Why after registration? Firstly, sub-registrar's offices, if we assume what will happen there, that is horrible. After presentation of the document, Humble impression is taken, execution is admitted by OP6, registration is accomplished, and document is retained. Why? I'll call this matter tomorrow. Issue emergent notice to OP numbers 1 to 5. Learned AG accepts notice for them. First of notice to OP number 6 is dispensed with at the request of counsel for the petitioner. who interfered while interaction was taking place between the court and the AGA. Delete that sentence. Call this matter tomorrow. If tomorrow...
Your Lordship, Your Lordship may keep it after vacation. No. Because tomorrow is the...
Because vacation is coming, officers will be in hunger. They will be in hunger. So tomorrow. Well, I want to know why this is happening. Yes. The officer should know that there is a court which monitors everything. This is a writ court. Why that sub-registrar? But tomorrow just make a statement.
Yes, sure.
I may call him here for giving some paritoshika. Yes. What is this happening? Everywhere is, I understand everything, everywhere, in every state these things happen all right. What about the common man? There are people who will have quid pro quo at different levels is another thing. But when somebody comes to my court, regardless of bad performance of the lawyers, I have to do justice. I can't depend upon the total performance of the lawyer. He is saying everything is done and still his client is not given. What is this happening? This is not one case. This is not one case. Many such cases are there. Cash certificates are not given. The building construction permissions are not given. My brothers, when we meet on Friday lunch, we discuss all these things. What are the problems of our people? How we should devise our plans. New innovations have to be done now. Passing order, your government will never care our orders. I know you have seen the other case earlier. You just tell your sub-registrar to see today's video. So that it should be an eye-opener. We cannot sleep over such matters. Yes. We know what to do to that sub-registrar. Yes.
Item 22.
Oh, call for one.
Please, my lords.
Yes, sir.
The petitioner is before my lords against the pursuable action of the NHI, my lord. OP number 4, my lord. The toll gate has been constructed.
The construction work.
Yes, my lord. Construction of the truck lay bay, a toilet of truck lay bay has been constructed in front of my homestead land. The toll gate has been constructed there with after 3 kilometers, my lord. The truck levy has been, the toilet truck levy has been started constructed by the NHI and the septic tank in front of my homestead land. From that land, they have acquired 2 goods, my lord, 8 decimal. And I am not staying there. When I came to know immediately, I contacted, but they had stated that no, as per the approval, we are making construction. At least when I have converted that land and for my residential purpose and other purpose, at least it can be shifted to 50 yards then backward or towards the front side so that I can utilize the main land. Your Lordship, I have annexed the photograph. Your Lordship, kindly have a glance. Page 24.
24?
Yes, ma'am. I have given a dependence notice so that it is available.
But the construction has already come up.
Yes, my lord. Construction has, I have started so. Close 7-8 feet they have started construction.
You will pay compensation for whatever expenditure they have incurred now. Why did you did not come here when the first founding stone was laid?
I am residing at Chennai.
Who asked you to go to Chennai? This state is so beautiful.
Business purpose.
No, you go there, but no problem. Do business there only.
But my lord, my resolution is from 3 kilometers away. This has been.
We do not know. Are you agreeable to pay for what has already been constructed at the public exchequer? It is your money, my money. Everybody's money. But at least the structure has after Taj Mahal is built. If you come and complain, no, that would affect the Yamuna flow of Yamuna river.
Well, before they started construction, at least they should say that this is a Gharavadi land.
Right. But that you should have come immediately to the court.
When I was not there, my lord.
You were not there, then you deposit rupees, how much money it is? You deposit rupees 10 lakhs now initially. Then we will issue notice. Otherwise, we will not issue. Because construction has come up, even according to your photographs.
Yes,
and he is not some tiller of the land, laborer, or SC/ST, oppressed class, rural background. He is the businessman who goes to Chennai. Otherwise, I am dismissing this. Go to civil court. When disputed facts are involved, how I can decide where to put up construction, which is right, which is wrong. Unfortunately, I do not know engineering, civil engineering.
No, the document will speak my truth, my lord.
How?
The construction, whether in front of the residential homestead land or not. Because when I have constructed...
They are constructing in their land. It's a case of damnum sine injuria.
But that doesn't mean that they will construct in front of a residential plot, my lord.
No, where is the prohibition? Show.
My lord?
Show, where is the prohibition?
Oh, my lord, when I have converted my land, agricultural land to homestead,
correct,
I have taken permission from Tahsildar.
Correct.
I have deposited the required amount.
That is, you have improved your property.
Yes, my lord.
How their construction comes in your way? What is your right?
I have a right to egress and ingress to the main road, my lord, NHI.
The main road?
Yes, my lord, that is the main road, my lord.
Main road belongs to whom?
The NHI, my lord, state government and
belongs to them, and they are doing whatever they want.
But they will take steps for the safety and privilege of the inhabitants, my lord. That doesn't mean that they will make construction in front of the inhabitant.
Covered by judgment of look into this judgment. Mayor of Bradford City Corporation versus Pickles. Mayor of Bradford City Corporation versus Pickles.
City Council.
City Corporation.
Versus
Pickles. Pickle, every day we eat, na? Achar. That Pickles. Where English court considered this aspect and rejected the relief. He said, it's a case of damnum sine injuria.
My lord.
There is no injury, but there is damage. Yes, nothing can be done. Just read and come back.
Yes, my lord.
All right, call after vacation. At the request of counsel from the petitioner. Can anybody take out that judgment? Which Winfield treats in a law of tort.
1895.
Correct. Right. So beautifully, the English courts have treated damnum sine injuria, injuria sine damnum. My professor was a great professor, Professor Desai. He used to teach law of tort. So beautiful, very interesting topic. There are good books on Indian side also. Ratan Lal Tiral Law is there. There is Bhagia's Law of Tort is there. There are good books. Even Samand has written on tort. One of the foundations of law of torts. Excellent book. Only thing is, books are destitute. Nobody looks at them. Yes.
First reopening with me.
First immediate after vacation. Sunday.
Item 23.
23, my lord, is a matter which is day for yesterday your lordship taken up, and learned AG was asked to take instruction, my lord, item number 40.
Yes. FIR.
Yes, my lord. The gypsum, transportation of gypsum has been.
What we get now?
Lalita Kumari. Which is that 2013? 15. Yes. No. May not be. Lalita Kumari is 2013. 2013 to ACC page 1 perhaps. Look into that judgment.
Yes,
2013. Yes, brother, what happened?
No instruction.
No instruction.
Mr. Mohanty, my lord, was there.
Follow this. Item 40, he has obtained the instruction. Well.
At 2.
Item 40. Yeah.
Item 40.
Yes.
Same matter.
Same matter.
Yes.
I have lodged a caveat. Have you filed the caveat now? Yes. Yeah.
I'll serve number 141. I'll serve a copy. Well, I'll serve.
Caveat can be filed even in a pending.
Yes,
yes. He become wiser after seeing governor instruction yesterday. Yeah.
And after your lordship's taken up the matter on day before yesterday, my lord, some developments are taken place. Now, government has issued a notice, my lord, to DG and IG of Police, District Administration and SP also to take action against, my lord, based on my complaint. Yes.
Then something is happening. We'll call this matter after vacation then.
First week.
All right.
And shall we copy it today?
Next week means you have to obtain a special order from Honorable Chief Justice.
I am sorry. I left it, lordship.
After your lordship's order, we have duly communicated the same to the authority concerned, to the
And
SP.
authorities are doing.
And they have to.
No, we'll say this matter has become
And apart from that, there was a understanding MOU between this association and this authority, my lord. So that is valid up to 2026.
2020.
So however, we'll file it in the form of affidavit, though we have got this intimation. And government has taken
copy on the cable.
I am also filing my memorandum. What has, all that has happened, my lord.
Anyway, you copy.
Yes.
Shri, fine. So, that senior advocate appears who happens to be OP number
6 and 7.
6 and 7. Not 8.
6, 7.
Issue emergency OP number 8.
6 and
Call this matter in the second week of October. In third week of October, we'll have. Second week is very completely busy. Third week we will have.
Lord, sir, I am filing memorandum, my lord, with all those developments.
Whatever you want to file in the office.
Well,
Okay.
I'll solve
a copy on the other side also.
Yes, I'll solve it.
Yes.
Only one thing, my lord, let there be no dislocation.
Huh?
Let there be no dislocation. The police authorities, my lord, they will ask not to cause any dislocation of transportation.
No, you want to pass such order. I have to hear the.
There is no IML. There is no interim application.
No interim order.
No, because this is only, my lord.
Call immediately after vacation.
Well,
Along with item 40.
Along with item number 40. In 40, notice is not issued.
Not issued. Notice not. I have only appeared. Your lordship has issued notice. Let my non.
Yes, sir.
Issue notice. Learned AGA, Mr. Lenka, AC. AC appears for OP numbers.
OP number 6 and 7.
6 and 7. And you appear for who?
Petitioner, in both the cases.
No, in that.
6 and 7.
Huh?
6 and 7.
in the first item, it is 6 and 7.
Second item also 6 and 7.
6 and 7.
6 and 7.
Notice go to 8, madam.
8, notice to 8.
Just name you. Who appears for whom?
Well,
Notice to 8 has to set.
Emergent notice to OP 8.
8, madam.
Call along with.
The state is for 1 to 5.
Yes.
I should sir, copy one set, my lord, to the state.
Yes. You also do it so that all matters will be ready
Yes,
for the next day. Okay.
Item 24.
My lord, maybe it may be taken off after lunch.
After lunch?
My lord.
Are you hungry now?
No. Mr. Satpathy has gone to Bhubaneswar.
We have gone to directly OP. I'll issue emergent notice. Any representation is made. Just see, representation is.
The representation
is made.
Final agent order, final order.
Issue emergent notice. Learned AGA, Mr. Lenka accepts notice for all votes.
Item 25.
Petitioners,
yes,
this case paper to antedate his benefit as has been extended to the similar situated person under Annexure 6 series. He has made a representation under Annexure 8, page 19.
Similar matters have I decided? Not yet decided.
No.
But I believe I decided one similar matter actually.
Annexure 8 my representation will consider taking into Annexure 6 series. Paper opposite, but not 2.
First off, the short grievance of the petitioners. One petitioner.
The petitioners.
Petitioner is as to non-consideration of the representation dated.
Sir, 13/8/2024 under Annexure 8.
13/8/2024 at Annexure 8, wherein they have sought for allowing the minimum grant in aid with effect from 1/3/1985 instead of 1/6/1985. First off, the net counsel for the petitioner submits that similar benefit has been accorded to other similarly circumstanced litigants.
Annexure 6.
As is reflected in Annexure 6
series.
Dated 8/8/24.
8/8/24 and 28/8/2024.
And 28/8/2024.
Page 50. Obtained under RTI.
Which documents have been obtained under RTI process? First, it tells the court that unless a proper direction is issued, their grievance should remain unconsidered indefinitely. Okay. Next paragraph. Learned AGA Mr. Lenka appearing for the OPs. There should be some music in the court hall also. That kills the boredom. Learned AGA appearing for the OPs 1, 2, and 3. 4 also.
No, sir, only 2, sir.
Only 2. 1 and 2.
2 and 3 direct, sir.
1, 2, 3.
1, 2, 3.
Sir.
3. Fairly agrees with the suggestion of this court that the subject representation of the petitioner should be considered in a time-bound way and in accordance with law if all contentions are kept open. First, this is appreciable. First, next paragraph. 8 weeks. Open to solicit. Now no courts. Item 26.
Within a period of
8 weeks.
Public.
The regulation matter.
Yes.
I have corrected the.
Covered by the judgment.
Yes.
Friend was there.
Yes.
Item 27.
Krishna is working as a junior assistant mailer since 12/5/1992, and in the meantime, he has already rendered 33 years of service. And the promotion has been denied mailer only on the ground that a vigilance PS case was registered way back in 2008. And now the juniors have been got promotion, Annexure 11, and the DPC they have only this one, and they have only stated, even though I was found suitable and zone of consideration, my name was there, but they have stated that promotion will be considered after clearance Vigilance Department. And now this issue has already been. Yes, I have relied on different High Court also has passed several judgment, including our High Court. I have relied on 7 to 8 judgment.
Have you given representation?
Representation I have earlier given. I have stated in my petition, but that representation may not help. I will file a face, madam.
There must have been a sealed cover procedure.
Yes, but that issue is already decided.
Will be kept. Sealed cover. There is one famous book by Unsealed Covers by Supreme Court lawyer. I forgot his name. Bhatia, Gaurav Bhatia. Unsealed Covers. Very interesting, good book, which you can look into.
I have relied, kindly see the judgment, madam.
No, that judgment, but problem is there is no recent representation at all.
The representation I have made on 17/3/25 that I have not enclosed because, madam.
Do you have copy?
Yes.
Give that to me.
They have also received that representation.
When you have copy and you do not produce it, doubt arises.
No. I am not giving it on the ground. He has the said representation he has made for retrospective promotion. That I doesn't want. He has paid for 2000 retrospective when the juniors got promotion. Judgment. This.
Our High Court judgment, this High Court judgment is also.
Yes, I have given total bunch of judgment. Karnataka High Court judgment, Madras High Court judgment, Madhya Pradesh, Allahabad, everything. And 2025, Punjab, Haryana also passed a similar judgment.
The short grievance of the petitioner is as to non-consideration of his case for promotion to the next level,
senior assistant,
namely to the post of senior assistant. Despite he being eligible and qualified for career progression. First, learned counsel for the petitioner very fairly tells the court that there was some vigilance case that was pending against the petitioner, against his client. What happened to that?
That is pending, only Vigilance PS case Annexure 5. 2010, the Vigilance Department issued a letter to the headmaster to production of the petitioner for inquiry. That is way back on 3/9/2010, referring to the Vigilance PS case
way back in September 2010.
And the Vigilance PS case was 2008, 54 of 2008. They have referred.
Way back in the year, Vigilance case number?
Kotak Vigilance PS case number 54 of 2008.
Slowly. My daughter has to write down that.
Kotak Vigilance PS case number 54 of 2008.
2008.
Annexure 5, page 26.
And the pendency still continues indefinitely. And therefore, that per se is not a ground for denying promotion to his client. First of all, he has placed on record a copy of his client's representation dated 17/3/2025, wherein he has aired his grievance. First off, he submits that if that representation is considered, keeping in view a slew of decisions of various high courts in the country,
including
the apex court decision in
State of Punjab versus
Chamanlal Goel.
1995 to ACC page 570.
He is trying to be satisfied. Next paragraph. Learned AGA Mr. Lenka, on request appearing for the OPs, opposes the petition, contending that there is no right to promotion as such, although right is for consideration. First off, he also points out that the subject representation is not made a part of the record, and therefore, if a copy is shared with him, there would be no difficulty for instructing the jurisdictional OPs to look into the grievance of the petitioner in accordance with law and in a time-bound way. First, counsel for the petitioner has supplied a copy.
Absolutely. Just no.
Take Xerox.
Only past page.
And give that.
Only past page.
Why in other pages you have kept something?
No, that is not representation. That is other document.
A copy of the representation is made available to Mr. Lenka by the court itself. Now, next paragraph. In the above circumstances, petition is disposed of, directing 8 weeks in accordance with life, open to solicit any information. Long dependency of vigilance case, 2008. How? Apex Court said in at least 2-3 judgment, at least 1 or 2 promotions must be given to employee, subject to the rules. The state of Bihar versus there are some such judgments actually. Samraditya Pal mentions that in his book. Yes.
Only consider in the light of that judgment.
keeping in view the decisions of various high courts and also the apex court. This board of.
Item 28. May I please? This matter relates to the regularization of the services as assistant professor in Ravensa University.
Similar matters.
Similar matters. You will also have.
AGA is party. AGA is not a party.
Yes.
AGA party.
AGA is party. Ultimately, the
AGA for 1 and 2.
1 and 2.
Emergent notice to
similar
3 and 4.
You will also similar matters.
We have already disposed of.
Yes, exactly similar dispute.
But they are not party. They here.
Yes, that is 1 and 2. The last paragraph 3, man.
Same order.
Man.
Then we have AGA for 1 and 2.
Man.
Others need party. Okay. Same order.
Oh, bless. Item 29.
Well, in 1998, the petitioner was allotted a house. 1998, and your lordship has dealt with similar matter. Your lordship dealt with, and 2025 now they are cancelled. They cancelled when I don't have any. Lordship kindly
issue emergent notice. I think it is a
BDA.
1 and 2 you. 1 and 2. Mr. Lenka or
only one.
Only one. Lenka for 1. Emergent notice to the rest.
2 to 5.
2 to 5. And learned senior advocate Mr. Mishra draws attention of the court to application in IA number 17482 of 2025 supported by affidavit wherein reprieve is sought for at the hands of this court, apprehending some coercive action pursuant to impugned order dated 28/7/2025 at the next date. First, he also tells the court that in similar matters this court has already granted interim protection and therefore the same may be extended to his client as well as the principle of bail.
Sushma Mishra case. Sushma Mishra.
Besides Sushma Mishra versus Swine. So any report, that report, is it not reported?
No, not yet reported.
Okay. Just report that.
It is AFR but not yet reported.
No. Just put that, right? Next paragraph. In the above circumstances, application is favored and the impugned order and all proceedings pursuant thereto are hereby stayed.
But the next matter is also same. The another person, same 98 allotment and same
same order.
The date of order is on.
The date of order is same.
No. Date of order.
Date of order is a little bit different ballot because another person. Date of order is same.
Give the names. Give that.
10/9/25.
Write down name.
The ballot.
Write down name.
What's up?
Item 30.
Yes.
The petitioner is challenging the initiation of proceedings under Section 91 of the OD Act, Orissa Development, Section 91. Yes, subsection 1, my lords, of the Orissa Development Authorities Act, as the same is without authority of law and without jurisdiction. In view of the 74th constitutional amendment
similar matters we are examining now.
Just now I am told that notices have been issued.
I have instruction to appear in the matter. I just half an hour before I got that petition copy and all these things. Challenging to section the maintainability of Section 91 at the instance of Cuttack Development Authority, consequent upon that 243 amendment. Pundu Ramaswamy and others.
Correct.
If I remember correctly, some of the decisions subsequently, so far Delhi Development Authority it has come up. There they say that a separate proceeding, that separate authority can be constituted also for the purpose. Here in this case, this area is not coming within the, what I've gone to just now, this area is not coming within the municipality area. This is coming within the Cuttack Development Authority area. Constructions are going on, unauthorized construction going on. The allegation is that you have not taken permission at all. So my humble contention, let it be examined, there is no problem. Let them stop construction, let them obey the order of the court, with that authority, and thereafter, my lords, it will be hard, there is no problem.
If he undertakes to pull down the building.
But kindly visualize one thing.
Yes.
this can be done. That I don't dispute that this cannot be. But fact remains, once they have undertaken construction and pulling it down, and waiting and participating there in the proceeding and to see that the proceeding to be concluded, you may also raise that point about maintainability. There is no problem in that. But fact is, once they have undertaken construction, obviously equity will lean in their favor. Thing is that these constructions are taken up when in a very posh locality that is adjoining that sea river and all these things. CCRZ zone provisions, many things are.
Take notice, we'll call this matter on 9th of October.
9th of
Because we can't start ongoing.
No, ma'am, that
That's the. Till then, you don't continue construction.
Yes.
All right.
Yes, ma'am.
Issue emergent notice. Let senior panel counsel appears for the OP.
OP1.
AGA for OP1. OP1. Call this matter on 9th of 9th. How many matters, brother? 16. All the 9th we will call this matter. There are other pending matters which are there.
Yes, my lord. These three items have also moved an interim application because in the meantime, they have issued letters to the TPCODL for disconnection of the electricity.
Don't disconnect the electricity.
So no,
I will not go with the construction.
You will not go with the construction, so there is no contingency of disconnection.
Learned counsel appearing for the petitioner draws attention of the court to IA number so and so supported by affidavit, where he apprehends that pursuant to impugned order, the supply of electricity may be disrupted to the building under construction, and therefore the same has to be halted. First, he assures the court that the status quo would be maintained without putting one single brick on the in the construction till the next date of the first. This is absolutely fair. Next, in the above circumstances, application is allowed, and the OP number 2 and 3. OP number 2 and 3 shall not take any coercive step for disrupting the power supply only to the building in question.
They are
similar matters. Sub items call along with. It's along with that same order.
Obligations.
Yeah.
Item 31.
Yes.
As per the instruction of the central government, the thermal power plant, they supply fly ash to the big manufacturing unit, my lord.
They supply
fly ash, my lord. Ash, my lord.
fire ash.
Fly ash, my lord. It is supplied free of cost. In the month of March, May, my lord, they have imposed some amount of rupees, 10 rupees per ton towards handling charges. That we challenge before the authorities, before the director of industries and before the collector. The collector took up the matter, but no decision was taken. I have made a representation by the Annexure 7, my lord.
If that is considered well and good.
Yes.
It's in Oriya or English?
Oriya, my lord. Annexure 7, page 49.
The short grievance of the petitioner kindly be seated. Sit down. Is as to non-consideration of, sit down and answer, of the representation dated 18/8/25. Sit down and answer.
My lord, that is 3/9/2025.
3/9/2025. At Annexure
Annexure 7.
7.
Page 49.
Annexure 7. Annexure 7. Wherein some grievance is raised as to the rate of fire ash.
Rupees 10 towards the handling charges.
Handling charge, by way of handling charges. First, council submits that. OP number 5 has to take a call in the matter. OP number 5, na?
4, my lord.
OP number 4, but you have written 5.
Sorry, my lord.
All right, just rectify that. Submits that. OP number 4 has to take a call on the subject representation. And there is no possibility, there is no hope that the representation would meet its fate unless the court intervenes in the matter. First, next paragraph. Learned AGA, appearing for office, fairly agrees that the subject representation shall be considered by the jurisdictional OPs. OP number 3. OP number 4. OP number 4.
Collector and the district magistrate judge.
OP number 4. The collector and district magistrate judge. If all contentions are kept open and a reasonable period is prescribed. This is appreciable. Next paragraph. In the above circumstances, the petition is disposed of. First off, 8 weeks granted for consideration of the subject representation after giving an opportunity of hearing to the fifth respondent, OP number 5, and other stakeholders, if any. Firstly, all contentions are kept open. It is open to OP number 4 to solicit any information or document from the side of petitioner as are required for due consideration of the representation. Registry to send a copy of this order to OP number 5 by speed post immediately.
Item 32. Maybe 52 may be covered by my lord's earlier order. There is a judgment passed by my lord and order for this. In case that BDA allotment, that cancellation of BDA allotment based on a task force reports. This lordship in the case, Sushma Misra, the lordship has already taken a view that when it is hopelessly barred by law of limitation, only factual difference is here is the person was dead, here he is alive.
That's the only difference. Any representation is made or order?
Based on a task force report of 2014, the allotment is of 2007 in my favor. 2014 task force report.
Take notice so that they also come back. Okay. Issue emergent notice, AGA for one. Emergent notice to the rest. Call in the first week of November, since matter lies in a narrow compass. Okay.
Not to
Senior Advocate Krishna.
Not to take. I'm sorry. Not to take position. The interim protection act.
Mr. Rath, learned Senior Advocate, draws attention of the court to application in IA number 17575.
Right.
Correct. Of 2025, supported by affidavit. Apprehending coercive action pursuant to impugned order. It tells that substantially the matter is covered by a decision of this court in WP number so and so, between so and so, disposed of on so and so, so and so. First, a prima facie case is made out for grant of interim protection. First, in the above circumstances, no coercive action shall be taken against the petitioner pursuant to impugned order till next day. Okay. Next.
Item 33.
That is my lord. May I submit on behalf of MK Sahu, my lord. The GI case disposed upon 27/2018. Thereafter, they have challenged that order before this Hon'Ble High Court in FAO. That is also
pending execution to be dismissed.
Yes, man. The similar order is SLP also dismissed, man.
Yes.
I have corrected one.
Yes, sir. Mr. AC, same order. Dr. Rahul Shah.
Yes, ma'am.
Yeah. Next.
Item 34.
Can I revert within few minutes?
Yes.
I have to sign the orders. Huh? Yeah. Generally, I sign my interim orders at around 12, so that they will reach your hands. Yeah. Yes.
Item 34.
My lord, I am a registered under the oral order of the appeal number 4
I supplied the scientific materials to different schools at Bhubaneswar.
Outstanding dues are not given to you.
My lord?
Outstanding dues are not released.
No, 8 lakh to 30, now pending 8 lakh 30.
Any demand is raised by you.
My lord?
Demand, any representation is made
Yes,
by you.
yes, my lord. After several representation under Annexer
1924.
page number 38, my lord.
To your legal notice also they are not replying.
No.
No
They are-
respect for
they are
the
not-
lawyers and no respect for judges also.
They are not responding totally.
They will not respond. They have made up their mind. Not even reply is sent to the legal notice. What a scant respect for the lawyers. Not understand. Even when legal, ordinary representation, ordinary man is cattle in your view, I can understand. Even lawyers are also cattle only. Not even one reply. And you will say just in September that is sent. If so many Septembers, Octobers, Novembers go on coming, going. You consider that you send reply to that notice first. Reply.
Yes.
Lawyer's notice should be replied.
Yes,
Short grievance of the petitioner is as to non-payment of outstanding dues in respect of the work allegedly accomplished by his client, by him. First, learned counsel for the kindly seeking. Learned counsel for the petitioner draws attention of the court to the legal notice of Annexure 4, dated 19/9/2024, which also did not result any action being taken on the demand made by his client. First, this is not a happy thing to happen, argues the counsel. First, next paragraph. OP number? Foreman. Learned AAC appearing for the OPs, although initially resisted the petition, saying that the matter may involve disputed questions of facts and therefore petitioner be relegated to ordinary civil suit, now fairly agrees to instruct OP number 4 to look into the grievance of the petitioner as is raised in the subject legal notice in accordance with law, subject to the caveat that all contention should be kept open. First, counsel for the petitioner is agreeable with this submission. First, in the above circumstances, petition is disposed of 6 weeks. Yes, it's not open to solicit any information, document from the petitioner if necessary for due consideration of the demand. Now, no course.
Item 35.
Yes. I have already received.
No, please, my lord.
Ex-parte, my lord.
My lord, it's a very simple mistake. Because I am appearing with the examination. They said one and they say.
1 second.
Sir.
Can you put off the mic? For some people, mic.
Yeah, sorry, sir.
For a few people, silencer is necessary.
Sir.
Yes.
Sir,
Yes.
may I draw my lordship's attention page 42, sir. When they have disposed of my representation, saying that as the petitioner, the third bar of the last, as the petitioner submitted the download OSS TET examination result 2021-2 issued Board of Secondary Education Cuttack, in which it is mentioned that not qualified at the time of verification of the certificate on 28/4/2022 and also could not submit the OSS TET pass certificate even during the process of inviting objection, for which he is also ineligible for the post of PET as per the advertisement dated 23rd/12/2021. Under the fact and circumstances above stated above, the claim of the petitioner deserves no merit for consideration for the appointment as a PET as for the advertisement number so-and-so dated so-and-so of the Director Secondary Education, Odisha, Bhubaneswar. Sir, may I draw my lordship's attention to Annexure 5?
I am unable to understand one single word.
Sorry, sir. That was got representation. Earlier,
hold back,
sir,
slowly,
sir,
one by one, pleasantly,
sir.
so that your adult judge will follow you.
Yes.
Is it not?
My lord is a very talented judge. It's not difficult.
That sentence I do not know.
Everybody knows my lord is very talented. No doubt.
No.
Anyhow, sir, may I draw my lordship's attention? Annex 5, page sir 33. Page 33, sir.
33.
Yes.
Yeah.
Annex 5.
Yeah, whether matter has come for the first time.
No. That
After
is
notice.
Yes, after notice.
After notice.
Yes.
But I am not disposing of any matter.
No. The other day also, my another counsel was appearing for the state that he was not qualified because there was a mistake of the portal. So for that, they have stated that he was qualified. He was qualified. Prior to that, they said that he was not qualified. It is stated both. Sir, page 34, it is stated not qualified. Page 33, it is stated he was qualified. Once he is qualified, then he is also his case to be considered. Because that is the mistake, not the mistake of the petitioner, the mistake of the computer, the portal.
Where is your representation?
Representation, they have disposed of my representation, sir. They have disposed of my representation by Annex 6.
Rejecting.
Yes, rejecting. On this ground, that I am not qualified.
Then let them file objections.
Sir.
Right.
Yes.
Any seat to be reserved?
Sir.
Any post to be reserved for your client?
Yes, let it be reserved.
One post you keep reserved.
Well.
So that tomorrow you should not say all vacancies are exhausted.
Recruitment here 2021.
I am qualified.
But here is 2021.
Because prior to that I am qualified. You said that the portal, because of mistake of the portal, you said not qualified. I can say qualified. What is this?
He has to say something as a government advocate.
Sir.
Otherwise, he will not get.
No. I don't have any of it. Let him say.
Yes, say no.
The recruitment year 2021. And subject to availability.
If any seat is anyway, many vacancies arise, na? Death happens, resignation, retirement. So many things happen.
I am sorry, but that recruitment year, that the vacancy would be advertisement.
But what is it? Yes, forms.
Thereafter, maybe vacancies are available there.
That also you can.
Yes, madam.
Issue emergent notice.
Notice ballot already issued. I will arise commit ballot.
Yeah, you have filed
only ballot filed.
Sir, have you filed the IA now?
Yes, sir.
IA number?
No, IA, sir. Sorry. No, IA.
No, yes. Then
no, I have not.
Call immediately after vacation. It is open to the petitioner to make interim applications for relief, if any, or in the meanwhile.
Always.
Yeah.
Item 36.
Yeah.
This is a commutation matter.
Commutation. Similar matters, what you have done?
My lord, your lordship has passed the order.
You did. Let's issue emergency notice when the day is the same one.
Same.
Sit down. When working, you should not stand up. Yeah. All right. Call along with the WP. Yes.
Item 37.
Yes.
So in the writ application has applied for a direction to the opposite parties.
You need mic.
Fraud is conducted.
What inspection?
I have made a
Did you eat ghee? You have eaten ghee, perhaps more ghee than usual.
Next up, for I have made a representation before the authority to take a decision on it. Based on my past experience, they may consider my case, take a decision on
For engagement as a junior lecturer.
Guest faculty. Against
Guest
vocational
faculty.
trade. Yes, against vocational trade. Basing on
what the grievance of the petitioner is as to maybe as to non-consideration of his representation dated 22/7/2025, wherein regard being had to 10 years of experience, he should be engaged against the post of guest faculty in occasional trades. First, learned counsel for the petitioner submits that the subject representation has to meet its fate at the hands of OP number 3, synonyms OP number 3, in accordance with law and within a reasonable time. First off, this having not happened, he submits, intervention of the court is warranted. Learned ASC appearing for the OPs, all OPs, very fairly submits that he would instruct jurisdictional OP to look into the grievance of the petitioner in terms of the subject representation and also keeping in view the extent state policy guideline. First off, he puts a caveat that all contentions should be kept open so that the meritorious decision is taken by the jurisdictional authority. First off, with this proposal, counsel for the petitioner is agreeable. Next paragraph. In the above circumstances, petition is disposed of 8 weeks for consideration, open to solicit any information, etc. Now, no course. Okay.
June 38.
Release of granting aid. Take notice.
Yes,
emergent notice. Any representation is made.
No representation is pending.
Issue emergent notice. ASC accepts notice for OPs. Okay.
Item 39. 39, it's a prayer for a direction to the opposite partner who want to fight to set aside the registration of committee granted in favor of the opposite partner number 6, my lord. My lord, since 1970, the petitioners as well as other villagers are performing puja in that mandap, my lord. OP number 7, pro forma is the donor of political land, my lord. But opposite partner number 6 surreptitiously formed a committee and deprived the present petitioner and other villagers to perform the puja, my lord. So that the petitioner filed representation before the collector, my lord, Annexure 1.
Has he got power to set aside registration?
No, my lord.
Then what should be done? You have to file a civil.
Only I have filed a representation before the collector. It may be
correct, but
it may be
what can be done in the matter? If he has power, if you show he has power to do something, I can.
Yes, I have a power. OP number 1 and 2, my lord, they had power, my lord.
Sure. Where is the power? Which section? Which act? Which statute? Under which law they have got power to set aside that particular?
Legally they have not registered, my lord. They have a fake document. They surreptitiously got registered, man. That is not valid, man. Illegal. That is illegal, my lord.
You said that it is registered.
Registration, but illegal way, my lord. They are not properly registered. So that I filed a representation for the OP number 1 and 2. Collector ADM Kendra, so that they verify whether the registration properly done or not.
Question relates to alleged illegal registration. Under which act it is? Go to
illegal registration of the committee named managed Sri Shubhalakshmi Crossing Bazar Banika Sangha
of a particular committee by the involvement of OP number 6 and 7.
Only OP number 6, my lord. OP number
7 also you have made it.
OP number 7 is the donor of the land. You proper donor of land in favor of us.
For conducting puja and worship of the deity in the temple that has been constructed in the land donated by OP number 7. First off. learned counsel for the petitioner submits that his clients have got right to offer puja and that the deity has got right to be worshipped in the light of pre-council decisions. Do you remember that decision? The right to worship, right to be worshipped in Hindu law, which the deity, do you understand what I'm saying? The deity, to remain sacred, it needs to be worshipped. That is called puja karya, nitya puja karyam. In Sanskrit, there is one sloka. Nitya puja karyam, nitya pushpachanam, nitya udakasnanam, like in Agama Shastra. They are there. But you have not seen anything, just you have drafted the petition to seeing just what your client had told you. But the bigger thing. Anyway, okay. Learned counsel on being asked under which statute the action should be taken, he tells that when a representation is given to an authority, it is for the said authority to decide what should be done with that. First. Next, for example. Learned ASC appearing for the OPs, although initially opposed the petition, now fairly agrees to instruct OP number 6. OP number 6.
It's a private respondent.
OP number 1.
Private number 1 to 5.
1 to OP number.
Yes, how many
jurisdictional OPs to look into the grievance of the petitioner as has been aired in the representation dated
10/9/25. 31/1/25. Sorry.
31/1/2025. Copy whereof avails at Annexure 1. Annexure 1. First off, he also tells the court to keep all contentions of the party open, including as to the maintainability of such a representation. First, with this proposal, counsel for the petitioner is agreeable. Next one, in the above circumstance, 8 weeks, open to solicitation, etc., etc. All contentions are kept open. It hardly needs to be stated that the inquiry, if any, shall be conducted after giving opportunity of participation to all the concerned, including OP number 6 here. For the registry to send a copy of this order to 6 and 7 by speed post. Yes. Lawyers who argue on worshipping, etc., they should read the Dharma Shastra. Otherwise, how are you going to argue? Absolutely. We should read Dharma Shastra. Then a lot of Dharma Shastra becomes part of our Hindu law, like Yoga Vasishta, Manusmriti, Manutika, Gautama Sudra. Okay? All these things you should read. There are best books on them. History of Dharma Shastra by P.V. Kane. Mahopadhyaya P.V. Kane. He wrote it in 2 volumes. He was a great lawyer. Some English just told him, you have so much knowledge, why should not you write the books on history of Dharma Shastra? He stopped practicing and started writing. His eyesight was becoming very weak. Then he prayed to the God, I have undertaken best work. I want to complete it. Never I have made any prayer to you. Only one prayer. Keep my eyesight intact till I complete the volume. And he completed it, and he died it as Shirvai did. Shirvai completed the 4th volume, edition of the constitutional law, and breathed his last. They are more like a Jatayu in Ramayana. Okay, anyway.
Item 41.
Lawyers should read best books, standard books from history, philosophy, everything. They should read even medical science. Yes.
Yes, this is an application for recalling the ex-parte order passed by Honorable Division Justice Javeri Millets, and in almost all cases.
Not name the judges.
No,
Passed by coordinate.
Honorable Justice, I said Honorable Justice Millets.
You should not name the judge.
That judgment in that order, I have already only for the recalling that order, ex-parte order. That is
Similar orders we have
similar
made.
also passed Millets.
After 6 years. But after 9 years, we have recalled in one matter.
Yes, after 6 years.
Government also. Yes. Which book you will give to the library? Give them.
Your Lordship, frequently directed me to give books. I have already submitted the book, but Lordship directions there.
There is other.
Almost all cases, yes, almost all cases.
In this,
My Lord don't know that.
you give history of.
No, I do not know.
It is just 7 volumes. About 20,000 rupees.
20,000, it is not possible. Only your Lordship not possible. Your Lordship know what is the position of the clients in the Odisha, and it is not possible at all. 20,000, your Lordship can say 1,000 to them all like that. 20,000 not possible at all.
You only tell which book you will.
No, your Lordship say, but within the cost you should not. Your Lordship say, I got deposit the cost minutes.
No, you get to put, cost if you deposit, it may go anywhere.
No, your Lordship.
They will call judges for party and they will.
No. Bar councils.
Bar
assistants.
Bar assist library. You, please listen to me. Listen to me. Give Story of Philosophy by Will Durant, one of the finest books. A small one.
All right,
Story of.
but that's not some subject availability. That is another matter.
It's available.
No, you are see whatever loss is posing, that is not sometimes not available. That has to collected from the other outside the state. So you also say that I can collect.
Yeah.
For some breathing time should be given. If they are not available, then
Hello. Okay. Subject to presenting the. Or give freedom at midnight.
all right, you are see whatever they say.
That is available.
All right.
Freedom at Midnight by Larry Collins and Dominic Lapierre to the association library. And you should also read that.
All right. I should do that. That should be
Best book about transfer of power. Yes. Yes.
Item 42.
42, my lord. Petitioner is the second wife claiming family pension.
Second wife.
Second wife.
Whether in
Yes, my lord. I am
Muslim or Hindu.
Hindu.
Whether a second wife.
Tribal, yes. That is apex court judgment for which the matter was.
Are they scheduled tribes?
Scheduled tribe. Not messy.
Will that let us see how
Apex court judgment. Second wife is anti.
Hindu marriage is not applicable to scheduled tribes.
Yes, my lord.
Second wife, provided marriage is contracted.
Yes, Lordship may see Annexure 4, page 13.
Annexure 4.
Yes, my lord. Legal head issued by the competent authority. Government has issued.
When first wife died.
My lord, she died. Lordship may see. Death certificate is filed.
I am just asking you. When she died.
Died, your lordship. Annexure 3, she died on 30/11/2004, my lord.
Yes. And you were trying to marry him when?
My lord.
Marriage took place when?
I think more
after the death.
My lord, your lordship may see that legal health certificate, my lord. There.
I'm asking it.
Yes, my lord.
I am asking it. I believe you.
Yes, my lord.
There is no reason to doubt you. Why should I doubt the lawyer? I will ask question. Whatever answer you say, I believe it.
My lord.
Yes. You have said date of death now.
Yes.
When the marriage took place.
Marriage just took place, my lord.
Because the judgment which you have given, that marriage took place after the death of first wife.
Well, I will take instructions. But here the Annexure 4 says that the first wife having one daughter married. Your lordship may see that. Page 13, Annexure 4.
Annexure 4?
No, my lord. The legal heir certificate, the deceased Ghanshyam Murmu, the first wife is this petitioner, Lord, Himani Murmu, second wife, married. Then second wife having 2 daughters, 1 son, and first wife having 1 daughter. That is serial number 5.
So family pension is payable to the widow. And she is widow. Therefore, she should be paid in circuit. Where is your application? That they have
Yes, my lord. Lordship may see Annexure 7.
You take notice, Mr. Behra. You accept notice.
Here is Union of India, yes, made party.
Union of India.
Yes. Plus state is also party because
Second is
your lordship may see Annexure 7.
Collector.
Collector. Collector has not the same proper that has been reflected in Annexure.
Issue emergent notice. First of all, learned ASG, Shri DSG, Shri so and so. There is no ASG in this code.
No.
DSG, Shri so and so is requested to accept notice for first copy. Learned AGAG accepts notice for second. Petitioner to make available copies of the petition along with all documents to them immediately. Since matter lies in a narrow compass, call it in first week of November. First week of November.
Basically, old lady may.
On 28th.
If collector send all the papers, my lord, matter could have been ended, my lord.
On 30th of October.
Item 43.
You take 43. I have filed an application for intervention.
And pass over, my lord. I am appealing for petitioner.
You want pass over?
Yes.
After lunch, you can see that.
Yes.
Yes.
Item 44.
Lordship, this present matter arises out of a GR case number of 2048 of 2014.
So, final disposal. GR case number 204 of 2014.
And since then, only one PW1
is examined.
Who is opposite party number 2?
You are for complainant. You are for accused.
In this, yes, in the GR case, we are for the accused, and in this present, we are for the petitioner.
You are on bail.
Yes, my lordship.
2014.
Yes. Only one PW1, the opposite party
lost
is
11 years.
Yes.
Why, Mr. G, why this is happening?
There is a long pendency of cases, my lord.
The repeated summons is being issued from 2023. Annexure number 2.
I'll put here. Long pendency of the cases are there. That's why they take so much.
Summons are not served.
The summons are being served. My lordship can say from 9/11/2023, the summons are being the same order is being continuing. The annexure number 2
means not served.
No, they issue summons every time that is.
No, I'm asking you.
Lord, I have to take instructions.
Will issue emergent notice to who are these people, opponents? Only the state.
The
private parties are there.
Private party.
Private Meenakshi Das is there. Registrar Judicial Katak Town Judgeship is there also at party. It made party to the registrar.
Who is party number 2? Meenakshi Das.
So she is the complainant.
Complainant.
She is the complainant.
You have not taken time before the court.
No, my lordship.
You produced the order sheet.
Annexure 2 is the order sheet.
Order sheet?
Yes.
How many times you have taken the adjournment?
My lord, we have not, instruction is to be taken, but
petitioners are directed to produce certified copy of the entire order sheet from first page to last page up to date on the next day of hearing, failing which petition runs risk of dismissal. On 31. Yes, entire. I want to know how many times you have taken adjournment. Having taken adjournment there, if you come here for early disposal, I will impose cost. Yes.
Item 45.
The petitioner has in IA number 17569 of 2025 for extension of interim order, your lordship.
application is filed IA number 17569 of 2025 for extension of the interim order dated 26/2025. First up. The grounds on which the interim protection was granted, Cabinet Council for the petitioner submits, still do continue, and therefore there is every justification for continuation of the interim order. There is force in this submission. Interim order is continued. IA is disposed of until further orders. Yes.
Item 46.
May I please, Your Lordship? My lords, I'm on VC, my lord. Unfortunately, I'm on VC, my lord. Unfortunately, my lords, because of I've hurt my leg, I'm unable to appear physically before Your Lordship.
1 second, sir.
Yes.
1 second. Whether for extension of interim order, if it has already expired, generally IA is filed. I'm just asking, I want to know. If it is going to expire, then a memo is moved for extension. What is the practice in your court? Otherwise, only we file.
Generally, extension IA is filed, or orally also we request Your Lordships to extend the interim order.
Orally also it's allowed.
Orally also.
It is also done, my lords. Yes, my lords.
Yes, sir.
If the IA is pending, then immediately this court extends.
Correct.
Yes.
It is not disposed of.
Yes. If it is disposed of, then a fresh IA may be required.
Yes.
After expiry also orally
Can be.
Normally IAs are kept pending.
Till next date of hearing, it is that kept pending.
Yes. IAs are stay
next date of hearing.
Yes. And the main IA is
Like
kept
39, 1 and 2.
Yes.
Okay.
39, 1 and 2 they have to dispose of.
No. 39, 1 and 2, if ex-parte order is granted. But generally, till after the appearance, the IAs are not disposed of in Karnataka.
Correct. Here, 39.3 is
39.3.
But at one stage, 39, 1 and 2 has to be disposed of. Here, the IAs are kept pending till final disposal of the writ.
Thank you.
Item 46, my lord.
Yes.
Your Lordship had heard the matter on the interim press, and these two miscases, that is IA number 11002 of 2025, which relates to the banning of banning order, and then 14235 of 2025, which leads to the termination order where we had challenged by way of interim applications. Your Lordships heard both of these and rejected them. But unfortunately, inadvertently in the order, it has been reflected that miscase number 14090 has been rejected.
It's as if
it's an inadvertent error, my lords.
So both the IAs are disposed of.
No, I'll help him, my lords. What he's saying is correct. I have corrected the order.
Yeah.
So the IA numbers have been interchanged. Only that.
Only that.
With your lordship's leave, we have corrected it.
Learned senior advocates at the bar have
in pencil I have corrected.
Board
the IA numbers only will change.
That both the applications, namely IA numbers 14090 of 2025 in WP number
in WPC number 18264. Yes. Would change.
Both the IAs are disposed of. However, somehow because of the mistake of the court, the order dated 3/9/2025 does not mention both the IAs, but mentions only one IA in one WP. First one. Next paragraph. In view of the above, the mistake is regretted and order is rectified. First off, a copy of rectified order shall be supplied if applied for free of cost.
That's also that.
14090 is actually the
Change will
miscase
No, I'm
of
held.
another writ application. Of another writ application, my lords, which relates to the blacklisting of the directors. Your lordships have kept that pending. And only these two IAs have been disposed of.
I have corrected it
It
accordingly.
is made clear
Yes.
that remains to be considered.
IA number 14090 of 2025 arising out of 23363 of 25 remains to be considered.
Remains to be considered. Obliged. Deeply obliged.
Corrected, my lords.
You have corrected everything.
Yes, I have corrected it. We are grateful to you.
Deeply grateful.
Next.
Item 47. Okay, sir, my lord, I will be permitted to withdraw.
Why not happy with the court?
To file a withdrawal application.
Okay. Counsel for the petitioner seeks leave of the court to withdraw the petition with liberty to approach afresh after doing necessary repairs. The request is accepted. The request is acceded to and petition is accordingly disposed of with liberty. Okay.
Item 49.
Hereby this FAO, my lord, I'm challenging the order of the Law and Tribunal, but in fact there is some delay, my lord. I filed an application for continuation of delay.
How many days delay?
Delay, my lord, according to me, my lord, 937 days.
957.
37.
37.
And
Other day we dismissed your similar matter.
No, that is the 19 order. They have approved 2024.
Yeah.
Here, my lord, 2030th order was passed on 30th November 2022. The appeal was filed, my lord, on August, my lord. Then delay of 937 days, and I have explained the reason, my lord. The dismissal of the GI case before the tribunal was never communicated by his lawyer to the appellant.
Take action against the lawyer.
But that is the one part. And second part, when I file a representation before the government, when similar person have already extended the benefit, now government have rejected my case, Annexure 8, saying that your case has already been rejected by the tribunal since 2022. Therefore, I came to know after passing of Annexure 8.
That was not communicated to you.
No. Annexure 8 was communicated only on 31st May 2025.
I think you went to that office, your client went to that office and got communication, one more communication. So that he will have.
Only I came to know, my lord, case 55.
But what is he? He is a teacher.
He is a lecturer.
Lecturer. Then he will be knowing if suppose if some rural man, some farmer, poor farmer, peasant, we can understand. He is a lecturer.
Lecturer not getting anything since continue 91 after putting 33 years of service. He is not getting anything from the government. One more interesting matter, the second post holder already got the benefit from the very same tribunal. Now that I have enclosed, he is the first post holder. And I'm relying 3 months judgment, which are going to delay. When the merit is there, also kindly consider this.
Notice is not a
notice is not first time that's one.
Issue. This learned AG is requested to accept notice for OP 1 and 2. 1 and 2. Notice to 3.
3 months.
OP 3. Okay.
Both on IA and as well as appeal.
Only IA is
You copy. You copy.
Yes, yes.
Yes, 51.
Item 50.
50.
My lords, item 50.
Yeah.
Before my friend starts, there was an order for complaints, my lords. I have received the instruction on 15/9 that it was not fully complied, and I had talked to them. Let it come after vacation.
If they do not comply the court orders,
my lord,
to close the courts.
My lord,
The government
no, my lord.
to the judges.
It was partly complied. He was paid 33 lakhs and he claimed some more money. It requires approval from the government.
There is a court order. Suppose approval, other day you said,
my lord.
I said the same thing. Suppose if the approval is not granted, on that ground can you violate the court order?
My lord, approval may be by way of rejection also. It is not that...
the order is made subject to approval.
My lord.
Somehow I am seeing this government,
my lord,
obeying the orders. Otherwise, you give some rehabilitation scheme benefit to us and we will go there only. Or give us land, we all judges will go for tilling instead of doing our judgeship. What is fun in having a court which cannot, does not get the orders implemented? Not this only one matter.
I know. My lords,
This is happening.
what I frame, my lords,
Yes.
I'll see that either way it is resolved before the next statement.
Lord, may I only may I only clarify, because for the last 3 dates, I've been seeing a particular kind of arguments being made that it is subject to approval. So approval could mean a rejection as well. I'm duty bound to bring it because it needs clarity, my lord, because
the authority does not approve
because
as policy reasons.
My lord, as it happens, my lord, if you speak falsehood 5 times, it may be taken up as truth. My lord, the fact here is they have admitted in their counter. My lord, may kindly have a
liability is admitted. His liability
admitted. Now, my lord, what was, my lord, may kindly see. So that understanding of my learned senior may not be correct. My lord, may kindly see just 2 pages. My lord, may kindly have the counter at page number 8.
Anyway, when Mr. Behr, something will be done. Generally, he has reported.
No, my point is he's saying even not done will be like done.
That as a lawyer, what option he has? The government lawyer.
My
No option. Can you say
my lord, it is a purely contractual matter,
But
and it should
These things cannot be re-agitated. My humble submission is, if this is the argument, my lord, let me be given a chance, my lord. I'll clarify it once and for all.
Mr. Behra, have a word with your client.
I'll do.
Other court orders.
Well,
That will. Do you know what is written? I told in other.
my lords,
I have said that.
personally, I have called just before.
Not only that, in American Supreme Court, it is written, whenever a citizen wins
Your
a
Lordship,
case
yes.
against the union government, the federal government, they call it, the federal government celebrates it because justice is done to the citizen. That way, we are not enemies.
My lord.
We are not enemies. Yes. Which date you will be able to do something in the matter?
My lords may call second week, 15th, your lordship.
16th. 16th, all right.
My lord.
30 minutes. Anyway, just reporting compliance. Yes. Mr. Padi is waiting for
Next item. Next item.
Yes.
Lord, 2 submissions, your lordships, that to reiterate, Lord, that water matter, the company was given allotted water. A was.
I have told you to look into.
They have done a lot of research. They have done a lot of research. They'll give to your lordships.
I said I remember.
Yes.
Subhash Kashyap's parliamentary practice. Because there are 4-5 paragraphs which of course, I may get it wrong also.
Queries raised by your lordships, including the meaning of exigencies.
Correct.
Including, my lord, the question of Nova.
Nova caused intervene.
Yes,
Nova caused the supervening.
In your lordships, 2 judgments in Karnataka, where your lordships, and in the Karnataka, your lordship passed 2 judgments. And in the High Court of Orissa also, your lordship passed a judgment. All the judgments have also compiled. And the English judgment of that 2 ships matter which your lordships wanted partial frustration. But the entire issue, they have done research that your lordships wanted. They have done research and we will have copies of that. But the petitioners had stated the facts. Your lordships, in fact, indicated petitioner completed the state to answer. But in that note, Lord, just to take 2 paragraphs of that note, Lord, not on the legal issue which your lordships have done, but Lord, your lordships is my gist of the case. I just wanted your lordships. Lord, in that two pages are just relevant posts, Lord. Paragraph 2, the entire case, Lord, so far as the non-deduction is concerned, the entire case is that the petitioner's representation dated 13th.
The engineer-in-chief had recommended.
It was not accepted, and it was not accepted till 3 years. B, my lord, then they made a supplementary agreement. It humbly submitted, my lord, para 3, that the government could have very well reduced the quantity in the contract. The government had a right, as per clause 32 and 30 agreement, to alter the quantity in case of exigency, which your lordship wanted the meaning, I have given the meaning. In fact, my lord, I had submitted to lordship that the government executed supplementary agreement for reduction of quantity from 10 for
Accepting the said recommendation.
accepting the recommendation, but 3 years after. Not the second, but while in fact, while my lord and lordship said, in government is not reducing the entire first part is not reducing the charge of the entire 10 cusecs for 3 years. That means I am using less 4 cusecs. I am asked them to reduce 4 cusecs. They don't reduce and force me to pay the entire amount. Let us, so far as applied for, there was justification to withdraw the letter. In fact, some amount of malafide your losses can impute. That they once when the agreement was to lapse in 17, they said that you come and have an agreement on the reduced quantity.
They withdrew from
last moment before, and I had no choice but to sign it. But second part is that the retrospective demand from October 2014 till January 2020 for water allocated at a rate applicable to irrigation. That means for the other word, the 2014, in one hand they said that your agreement is there, you can't change. The other hand they want themselves. So it is, you can't approve it
that way.
That is the principal account. The subsequent findings that so far the findings of the principal. But I had just an idea about, of course, without going to nuances of law. I had asked some senior principal AGs and what is the concept of this AG objections and CAG's report. I was made to understand the AG office operates of his own and gives and flags up certain concerns to the government. Then these are our concerns, which has to be viewed seriously by the government. Then the government may accept it, may not accept it, gives back. All these are not part of the CAG report. CAG report are like Bofors case, serious matters. They are part of CAG to the principal. These are all day-to-day basis. They flag off concerns. Then the government is to examine, and that means
take a decision.
And take a decision, but it's a matter of serious introspection. There's no doubt about it, but not a matter of ruling of the AG that must be.
Which would affect rights of the citizen.
Rights of the citizen. And the para 10, not so far as I am concerned, your lordship may hear the government after lunch a matter has been fixed. A matter has been fixed. Mr. Mahathir is there, he will do. Mr. Mahathir is there, I will leave.
Very grateful. Because of your argument, I read Erskine May on parliamentary practice. I could not get Subhash Kashyap's book. If that paragraphs are there. What is the, of course, now you have clarified it is CAG's role is different.
AG's role is flagging of concern. Government is to have
I remember having argued one matter in Europe versus so and so.
Yes.
I had argued similar matter.
Yes.
Could you get that judgment?
We have got another judgment which they have in Supreme Court, which carves out what is the responsibility, as my learned senior said, what is the responsibility of a CAG and how are the reports to be interpreted. And we have given it, man. We have given
Arvind. Was it Subramania Swami?
No, we have given two, which is 2013 Arvind Gupta judgment, my lord. And another is Uttar Pradesh Power Transmission Corporation, Supreme Court 2021, which talks about the ambit of CAG report.
So what you possibly your lordship can consider the state. Thereafter, as your lordship said, and whatever your lordship close the matter, then any clarification.
Thank you for making me to learn so much.
Your lordship
so beautiful. Yes. Afternoon? So that during vacation I don't have another job.
As they say that the learned judges say that we work 5 times more than the lawyers, which is a fact. Lord, I'm not telling your lordships to, because
brothers also work more than me, actually.
No, I'm not saying of
my brothers and sisters.
No, I'm not saying of particular High Court, Lord. The judges work 5 times more than the lawyers. Maybe the lawyers have 5 times more anxiety than the judges, but the judges work more.
In fact, we were at least I was not told that so much work. The seniors in my Bangalore, they misled me. I told them I was not interested in elevation. I'm not cut for judgeship. I'm cut for lawyering. They did not tell me how much workload will be there. Like somebody being driven to the marriage mandap, whether marriage will be great, etc. You marry this.
There's a lot of time for lordship to go back to practice after that Supreme Court.
All they were great friends. Yes. Very good. Thank you. Thank you. Yes. This you keep that one. Yes.
I was a little late, my lord, my lord, because my associate was praying for adjournment. I don't know, 24, my lord. Your lordship, my lord. Your lordship.
No, we have issued emergent notice.
But what happened, my lord? After retirement, is not getting any benefit, my lord.
Yes.
That is why I made a representation on Annexure 1. Your lordship also, my junior also told me that. Lordship asked for is there any representation is pending, but since you brief was not with him, he is not able to submit it for lordship, my lord.
Which date we have?
I told 24.
No date. I think I have signed the orders also. I have signed the orders also.
He will not sign it.
No, I signed because at 12 I get an urgent orders I signed. And again, I went and signed all papers and then I came after attending some meeting. If it is not signed, I will look into just show that.
I don't know one that is pending.
Let us.
I don't mention my letter. Some cover-up matter kindly taken up tomorrow.
Cover-up matter?
Ananta Chandran Bhaik.
Today?
Tomorrow.
Take it. You are going for a vacation where?
No, my
you are going to. You are not going anywhere.
No.
Then you have it after vacation.
No, my lord.
Item 51.
May I please?
Yes.
My lords, I had, on last occasion, I had raised some submissions, objections, and your lordship has noted down so that I am not repeating that. I am sorry. My lords, my first submission.
First submission is what?
My lord, there is a concluded contract between the parties.
Correct.
Parties are abided by the terms of the contract. I'll bring my lord's notice to some clauses of the contract, which is required for execution of this case.
Yes, sir.
My lord's page 114.
114.
My lord, page 114. Clause 12, my lords. My lords, exigencies, I want to draw your lordship attentions. These are the conditions that Messrs. Impa should not claim as a matter of right to get desired quantity of water during non-monsoon and lean period to meet their full industrial use. And the company has to make adequate storage facility for a period 3 months in their own land. What I beg to submit, my lord, that government is concerned by, my lord. Another clause, clause 25, my lord, at page 115, my lord. Drinking water and irrigation water. Drinking water and irrigation supply to the command area of Mahanadi Basin shall get priority over the supply of water to the industry. Hence, my lord, what I beg to submit that
they can't claim more than what is allocated.
My lord,
even allocated also they may not get. The underlying
my lords, why my lords, preference is given
drinking water
and irrigation farmers, and this is for commercial purpose. This use is for commercial purpose.
No, their case is reverse.
My lord,
their case is we do not want water. That is their case.
My lords, I'll come to that, my lords. So that is because it is unilateral power of the government to reduce, my lords. They have agreed to that, my lords. They have agreed to that. They cannot say, opening their eyes, they have signed the agreement, contract. They cannot say now, we are not binding by the terms of the contract.
Learned AGAs Behera submits that the rights and obligations of the parties are articulated in the contract, and therefore beyond the contract nobody can be permitted to travel. First, in support of his contention, he draws attention of the court to paragraph number 16 and
25 and 32.
25 and 32.
Clause 25 and 32 minutes.
25 and 32.
32 minutes.
32.
32 says, my lords,
allocation is of exigencies.
Okay. Government shall be at liberty to review the other allocation unilaterally in case of exigencies. Exigencies, your lordship will see that exigencies, monsoon, there may be shortage of water, drinking water may be that in that case unilateral, my lords. Like of course, there is no provision, no terms in the contract to seek reduction of the quantity of the water.
He submits that there is no provision in the contract, no clause in the contract that vests any right in the petitioner to seek reduction of consumption quantity.
My lords,
the quantity is specified in so many words in the contract in question.
My lords. Now, my lords, so, my lords, the recommendation of the engineer-in-chief is not as per the terms of the contract. So, that has no binding effect on the parties, my lord.
He adds that the recommendation of engineer-in-chief does not bind the government, obviously the same being recommendation, and that the intent and content of the contract in question do not accommodate such a recommendation.
So, it's the recommendation doesn't entitle the party for reduction of allocations.
In any way, the recommendation is not justiciable, and non-acceptance of recommendation does not give a coherent cause of action to the petitioner.
My lords, the agreement was entered into in 2014 for 3 years. And as they had asked for reduction, my lord, my lords, kindly turn to page 93, Annex 10, my lords.
93.
My lords, where the petitioner was asked to sign the agreement with the reduced 93, my lords.
That is after the period of first agreement was over.
No, before.
When the first agreement was getting over?
2017, my lord.
2017.
2014 to 2017, my lord. 2014 to 2017, my lord. The first agreement was signed on, my lord,
6/8/2014.
6/8.
2014. 3 years.
6/8/17, it is going to be expired.
But on 13/6/2000, 6/8 it is. So 2 months
before.
But when recommendation was sent to you?
My lords, this is the director's water services allocation. He has taken the decision that let us reduce because we are going to.
I'm asking you.
My lords.
The recommendation is dated what?
My lords, that is.
Date, sit down and answer.
13.
My lord, the recommendation of the engineering chief.
3/8/2015.
3/8/2015. Okay. Then
No, my lord, that's not the correct. 29, no, may I? 29/9/2050.
29/9/2050. 9/2050.
My lord, Annexure 8, Annexure 9, page 8.
When decision was taken.
Decision was taken, my lords, in up 2018.
2/6/2018.
So I am coming to that, my lords. Here, my lords, he was called to sign the agreement at the reduced quantity, my lords. What he did, my lords, petitioner did, registered this letter, registered the letter by letter dated 22/6/2017, page 101, my lord.
One.
My lord. My lords, his letter is at page 102, Annexure 12. My lords, what happened here, my lord?
It's another suitability.
My lords, what happened, my lords? In 2015, there was a resolution. By resolution, there is a demand for water consumption fund. That is conservation. Water conservation fund. He was asked to pay that fees. He has challenged that before this Honorable Court by way of a writ petition. And subsequently it was reduced. And he paid also, accepted that he paid also. In that letter, he resisted that imposition of fund, not that reduction. And my lords, when he did not sign the agreement and asked for deferment of the agreement, in the meantime, government wanted to know the justification of reduction. Nothing wrong in it, my lord. Why you want to reduce your allocation, you give justification, my lords. After justification is given, it was reduced, and at the reduced quantity, he has signed the.
They had given justification in his letter saying that Supreme Court has said,
my lords, not.
Or I cannot make.
My lords, I'll bring your lordship to that protest. He has stated that deallocation and other reasons were not specified.
That deallocation is mentioned. It is pursuant to Supreme Court decision.
My lords, what happened, my lords? Then they wrote a letter that we want 10 cubic sec. That letter, your lordship can see. (31/7), my lord. Page 105, Annexure 15.
105.
My lord.
There also has mentioned about Supreme Court order.
My lords, no, my lord.
Yes.
Yes. My lord, second para. We humbly submit that our request, our present agreement is going to expire on the renewal agreement for drawal of water may kindly be executed at the earliest under the same terms and conditions and the conditions quantity pending disposal of our representation by the state.
Because that was not disposed of.
My lord. So, my lords, now that they have themselves admitted that we need 10.
Where have they said?
My lord,
disposal of the pending decision by the government.
my lord.
The recommendation was.
My lords, and then, my lords, they have entered into another agreement on the same terms and conditions.
No, reduced quantity.
No, my lord. Same terms.
Was it not reduced quantity?
No.
because the decision was pending.
Because my lord, they withdrew it, my lord, as it was argued, my lord, 24/8/2017, my lord, it was expired.
One second. Mr. Behra, are you suggesting that this amounts to waiver of the right? Whatever right?
My lord.
Mr. Behra, taking the court to petitioner's letter dated 13/7/2017 and annexure 15, page 105, submits that petitioners have waived whatever right they had. Petitioner had waived whatever right he had in seeking renewal of the agreement, the same terms,
And
which includes the same quantity of water as well. First, into bracket, just say that in the first paragraph, no, just in the bracket, pending disposal of our representation by the state, bracket complete.
so, my lords, the protest regarding the fund, my lords, not for this quantity, my lords. They entered into another agreement by the
Behra,
my lord.
kindly come to page 15, annexure 15.
My lord.
What is meant by pending disposal of our representation by the state government?
My lord, sir, because it was not concluded, there was no decision
In the
for reduction, my lord.
Therefore, they say, I cannot stop my industry. I need water.
Well,
In this imbroglio, I cannot start that way. They said, all right, you renew the agreement with the same terms.
my lord,
Let it be subject to decision of the
my lord,
government.
my lord,
Then government took a decision.
my lord.
Then it is subject to decision.
My lord, government took the decision
To reduce it.
reduce it, and it was done after he justified that that letter I will bring to your lordship notice. That is not only the allocation, there are other reasons. My lords, their letter for giving justification was letter dated 3/10/2017, page 118, my lord.
Good. What to that? What?
My lords, what's last? For the sake of brevity, we are stating the rationale for reduction of water allocation as below. B, my lords, 138 megawatt power plant and charge from furnaces shall consume to push water by thereby reduction of this.
The mentioned Supreme Court.
Apart from that, my humble submission before my lords is that that was not the only reasons available to the. So after justifying all the reasons, government applied its mind and reduced it. That is my submission.
It reduced it.
Yes.
Then that should inure to the benefit of earlier agreement also.
My lord's earlier agreement expired in 2017, my lord.
Correct. But before that had made the representation.
My lord's making representation doesn't entitle him to reduction, my lords, unless it is done by the competent
terms of the contract.
My lord, competent authority.
You have power to reduce even under the terms of contract.
My lord. Review. Exactly, it is reduce.
English word.
My lord.
That's all.
My lord.
Review is for that purpose also. Either to reduce or else as the case may be also, but it is more reduction.
My lord.
That the term is coined that way.
My lords, there is two parts. There are two parts. One is refund and another is demand, my lord. Now we are confining to refund, my lord. Refund, my lords, the reduction was not done. Because of that, the petitioner filed a writ petition before this honorable court. That is WPC number 2631,
which he withdrew.
My lords, 2631 of 2017. The challenge was inaction, not reducing the quantity. And in that case, they unconditionally withdrew the case since the reduction was already happened.
Yes.
And court observed it is only your lordship may casual remarks. It is open for you to make application for refund.
Yeah.
If it is permissible, it will be decided. My lords, as per the terms of the contract, there is no provision for refund of tax. So that question of refund
does not arise.
And my lords, adding that, my lord, it is petitioner has waived, my lords, because the refund application was rejected in waiver 2019, my lord.
Yes.
And the writ petition was filed after 2 years and odd days without assigning it is a company, my lord. Had it been a villager, I can understand.
Mr. They have asked permits that the petition is belated in as much as
it was rejected on 15/3
for reduction of the quantity of water was done on 15/3.
No, my lords, refund application was rejected on 15/3/2019.
That is, you are speaking about second petition now?
No, my lords.
In this only?
My lords. That petition was, my lords, done at page 149, my lords.
Yeah, they have said that. Done with liberty to make application to
refund if you. My lords, what I
is believed, and therefore, in the absence of any plausible explanation, no relief can be granted.
My lords, the refund application was rejected on 15/3/2019.
The refund application having been rejected 15/3/2019.
And the
writ is filed in 2021.
38/2021.
August 2021.
21. My lords, the conduct of the party, it is a delay and license one ground. And second is that, my lord, by slipping over 2 years, they have waived their right, accused their right to get the refund.
Under law of limitation.
My lords, 3 years.
Suit for recovery of
3 years, my lord, admittedly. That I...
Justice Hidayatullah said in one judgment, considering the petition, whether it is time barred or not, ordinarily whatever period is prescribed in law of limitation, in the schedule to law of limitation, should be kept in.
My lord, but what I humbly submit, it is when party in a contractual matter before a rate court, my lord, should assign the reasons. Why delay occurred for so? It is not 1 month, 2 months, 2.5 years, my lord. By that process, my humble submission is that there is no intention to challenge that on till the demand is made for next demand is made, my lord.
It's a delay in latches. Yeah.
My lords, so my lords, refund application was rightly rejected, and in a re-jurisdiction, my lords, I'll cite one judgment recently passed in GMR case, my lords, where the Honorable Apex Court has quoted NHS judgment of 2020-22, stating that court normally would not rewrite the agreements or impliedly construe a clause for benefit of any party. It should be expressly stated. Whatever expressly stated, that should be adhered to, my lords.
GMR is infra.
My lord. So, my lords, here, in the present case, there is no condition of
citation.
My lords.
Mr. Behra, processing to service, Apex Court question in GMR Infra versus joint. So, to the effect that court cannot rewrite a contract between the parties.
Manu SC.
Manu Patra, SC.
0422.
0422.
By 2023.
2023. Just give a copy of the mail with those.
I am placing my lords.
Court cannot rewrite
it is settled.
Between the parties was taught to me,
my lord,
in the first year of law itself.
My lord.
But it
is settled, my lord.
Many meanings it has that.
It is said that the proposition that courts cannot rewrite a contract mutually executed between the parties is well settled. The court cannot, through its interpretative processes, rewrite or create a new contract between the parties. The court has to simply apply the terms of the and conditions of the agreement as agreed between the parties, my lords. So, my lords, here the conditions doesn't provide for giving liberty to the petitioner for asking for reduction of the quantity. Okay.
Water quantity. But if that is so, how could you alter the source of water under the very same agreement?
My lord, my lord, I am coming to that.
Yeah.
This is second part, my lords. After the CAG report, a high-level committee was constituted to ascertain the source. What is the source about? How it is? They are in their findings stated that Mahanadi, there is a barrage. In upstream, there is a barrage which scatters water for 100 kilometers in the downstream. And in the upstream, there is a Naraz barrage which is used for agriculture purpose. That report and audit report was supplied to the petitioners. They have not challenged that. After seeing that, they admitted that it is a irrigation source, not the government source.
Where are they admitted?
My lords, 2021 agreement.
No, it's a separate cause of action. It is subject to decision of the government.
No, my lords, that is related to reform.
No, I'm asking you.
My lord.
Say,
my lord.
You cannot rewrite. You told the court you cannot rewrite. It's true.
My lord.
That principle is much older than the Supreme Court.
My lord.
Question is, you also unilaterally cannot rewrite.
My lord. My lords, we have we have reduced the quantity as we have permitted under the contract.
Very well.
Well,
Now, it is another contract. From 2014 to 2017 contract, the
Right.
first contract we may call it. How can you alter the terms of the contract? That contract said, the nature of source of water is this.
my lords, that I'll confine that argument. Now I am coming to the second part. The learned senior advocate in first submission stated that it requires reconsideration. And my lords, so far audit report is concerned, it is settled principle in revenue laws. You cannot make a demand on the basis of the audit report. It can be a basis for reassessment, my lords, by confronting the report and giving opportunity to the.
Even that you could not have done.
My lords,
The body sir said, once contract, for your purpose, you say you cannot rewrite the contract.
my lord.
When it serves you, you say, I want to rewrite the contract.
My lords, I have limited the submissions in that regard. I will bring your lordship's notice to clutch. It's a specific clause that in case of any dispute arises out of the contract, my lords, the matter should be brought to the notice of the government, and government's decision is the final.
That is not acceptable now because of Apex Court decision saying that where government has unilateral power to decide, all those clauses should be held to be void, which is that judgment. That judgment came in arbitration clause.
Arbitration, there is a amendment made that government or party to the contract who is beneficial to the contract cannot appoint arbitrator unilaterally. There is a provision in that, my lord.
Where is the dispute?
My lord,
To go for
my lord,
anything, where is the dispute raised by the other side?
my lord, the dispute is that the engineer is not the government. He has made a demand for on the basis of the audit report and high-level committee report. That report was not challenged. That confirms that the source was irrigation source from the beginning, my lords. And the demand was made. That is the dispute. They say that it is not payable. That should be referred to the government, my lord. There is a clause, specific clause for that.
The government has taken decision and he should be.
No, government has not.
Government should go,
my lords,
and seek mercy at the hands of the wood.
my humble submission is that government has not taken. My lords, first order is passed by the government.
Yes.
Refusing refund.
Yes.
The second order is not passed by the government, my lord. It is by the engineer. Engineer is not the government. My humble submission. When there is a alternative remedy available under the contract.
But confidence should be there, na? Alternate remedy, when question of alternative remedy,
My lord.
of course, no writers have written and addressed it. I don't know why they have not. Unless I have faith in the government,
My lord,
I cannot be driven
My
to the
lords,
government.
with all respect, I'll humbly submit, my lords, that we cannot presume something that they are biased or.
No, Supreme Court said.
My lord.
Apex Court said. Generally, we operated.
And my lords, here, the moment petitioner pleads coercion or undue influence, that is not a matter to be adjudicated in jurisdiction, my lords.
Where is the coercion, they have said?
My lords, they have said that before 2 days they influenced and asked us to sign.
That is another agreement. Okay, don't worry about the other agreement.
My lord.
We are not on the agreement at all.
So far, my lords,
We are in the first
my
agreement.
lords, so far this demand is concerned, my lords.
Mr. Behra, You are a very persuasive government advocate, I understand. There is a merit in the decision of the government. And you ask us to go to the government. Well, who has faith in the government? Sorry to say this. There is one famous judgment of Lord Atkin. Lord Atkin said about his government very long ago, presumption was because we believed Raja Taksha Devataha, that he will not do injustice to anybody. King was God for them. Therefore, king can do no wrong. That itself is diluted in England after the passing of Crown Proceedings Act 1947. King can do wrong. Therefore, Article 299, contractual breaches, etc., 300, state torts, these are there. Therefore, the presumption that Raja Pratyaksha Devata, he is the God incarnate, therefore he will not do any wrong. That is the reverse of that nowadays. In most of the litigation, state is a party. And we have been seeing how the state works here. I agree. Everywhere, maybe in different proportions. The extent of illegality attributable to the state is in varying degrees, not in kind. When it comes to government, ask anybody. I can just go.
My lords, I was going through some judgments where it is stated that government is acting through a particular person. People. His conduct
is government's got. What to do? Government on its own does not work.
My lord.
It is the people who work there.
My lord.
People, we have a problem with the people.
My lord. Now, my lords, I will bring my lord's notice to clause 14
of contract.
In case of page 114, your lordship pending.
Clause
14, my lord. 1/4.
In case of any
interpretation of law arising out of this agreement, the same shall be referred to government and to decision of the government.
Department will be final. The government took the decision.
No, my lord.
It will not reduce the quantity.
My lord, I am now on the demand, my lord.
I am on quantity now.
Quantity, my lord, it was concluded by reduction in 2018.
That's all right. It's the government. The question is, if it is a refund, again, you mean to say it should go to the government. Now we have taken the stand, no belated and no.
My lord, that is in respect of the refund application, my lord. Now I am submitting on the demand made on the basis of the 2021 demand made on the basis of the CSG report and high level.
What is the status of CAG report in the eye of law? It is not CAG report.
My lord,
the report of the Auditor General of
my lord.
PAG, my lord. Principal Auditor General.
My lord.
PAG, my lord. Principal Auditor General.
Comptroller and Auditor
My
General.
lord. My lord, here is that is the audit report.
So what base it has?
That brought to the notice, my lords, I'll bring your lordship to that report itself.
Whether the report, a copy of that was given, was he heard in the matter?
He was given the copy.
A copy and decision of.
No, my lords, after the decision, he was given the copy. He asked for the copy and he was given.
Already you had taken the decision.
My lords, that is why I humbly submit, my lords. That is why I humbly submit. It requires, and the learned senior counsel also was of the same opinion, it requires re-look in view of the, my lords, now my lords, kindly, it was...
EGA draws attention of the court to clause 14 of the agreement, which provides for reference of any dispute to the government for decision. And that would be final.
No, my lords, kindly come to phase 2002.
Therefore, the court should not interfere.
My lords, kindly come to 211 page, that is the CAG report. PAG report, I stand correct one. The last para. The last but para was placed by the petitioner. I am placing the last para. The reply is not acceptable since location was between Naraz Barrage and Mahanadi Barrage. It was charged with water of Naraz Barrage constructed in the upstream of the Mahanadi Barrage. The Naraz Barrage had no independent and was constructed to control flood and supply of water to Mahanadi Barrage from the water from where irrigation was provided through canals. Therefore, the location was well within the irrigation system, my lords. Then, my lords, so kindly come to page 207.
So you constituted the committee?
My lords.
Based upon the PAG report?
My lords.
And did you hear the petitioner?
My lords, he was not heard.
Was not heard in the matter.
My lords, what I humbly submit, after getting this report and this High Committee report and PAG report, the clause 14 is available to the petitioner, where he can refer the matter to the government as per the terms of the contract. That is my submission, Your Lordship.
This report, on the basis of report, who took the decision?
My lords, this is the demand was raised. Demand was raised by the engineer to
the contract.
No.
Then why there is the dispute? Where is the dispute? Dispute between the parties.
My lords.
Dispute in Cuttack market is not our place.
My lords, my lords, asking reduction to is also not permissible, my lord.
No, that's not it. That I will treat separately. You are banking upon the clause for reference to government for dispute resolution.
My lord.
Where is the dispute? Dispute officers say something else. So how that is going to raise the dispute?
My lord, dispute is that when dispute is as interpreted, my lords, where there is a claim and refusal.
Claim by A, refusal by B, who are parties to the agreement, will give rise to dispute. Agreement is between A and B. X, Y, Z, they will raise a dispute. That is also dispute. Dispute is defined under the Arbitration Act. At least there are judgments.
My lord, there are a number of judgments.
One judgment I treated violist in Karnataka. Take out that. Dispute means, Justice Krishna Dixit on dispute. I was known as Krishna Dixit there. Yes. Existence of dispute, where is that? Which is that judgment? That's the judgment. Like this, Arbitration Act. Arbitrable dispute. Dispute. Like this you take that. Yes. Can you find out that the judgment? I believe that it is affirmed by the apex court too. Do you have arbitration act? How dispute is defined in arbitration act?
I think
Because under the Industrial Dispute Act, difference is treated as, because it defines dispute or difference. But that is not there in your this one, Arbitration Act. Arbitration Act dispute.
Yes. And dispute has been interpreted by this way when there is a claim and refusal.
By the parties. Not by people in the market. Because doctrine of privity of contract applies even when we are construing the term dispute. It should be between parties to the contract or anyone claiming under them. There are judgments. G. Krishnamurti versus Vaishnava. So, don't remember, my memory is fading. And your court does not provide me any researcher. No. Anyway, now the DG submits that because of PAG report, a high-level committee was constituted, and that recommended for the acceptance of the report of the PAG. First, when asked whether PAG or the high-level committee had given an opportunity of hearing to the petitioner, in all fairness, Mr. Behra concedes that no such opportunity was provided. Yes.
Well, it's the demand on the basis of the report was made on 23rd July 2021, my lord. And by letter dated 31st July 2021, the petitioner disputed that they are not liable to pay.
Who sent the letter?
The superintendent engineer.
So he is not a party to the contract.
He is party to the this not contract on behalf of the state, my lord.
Only state government is the party.
Their authorities under the...
No, government is defined under the provisions of government, the General Clauses Act.
My lord. Is a party here also.
To the contract also?
My lords, this writ petition is a party.
No, writ petition all right, because he said something against them, they have made him party.
My lords.
But
What I humbly submit, my lords.
No, let's understand what is government? Who are the parties? Let us see. Go to the agreement, the title, cost title of the agreement.
My lords.
The addendum clause of the agreement. The agreement begins at?
My lord, sir, 1 minute. Your lordship, 110, your lordship.
Annex 142.
18 also same.
Agreement is made on.
No, this agreement is made.
2014 agreement. Page number 310.
100 my lords.
2014 is page 57.
57.
Annexure 3.
Agreement is between?
This is
The governor of Odisha.
my lord.
Governor means government.
Government.
You have said it also.
My lord.
Government.
My lord.
Even otherwise it is government because of Maruram versus Union.
My lord.
Then he is not, the government has not read that.
My lords.
How the engineer will ask them to do all these things?
My lords, under the contract, the functions to be done by the engineers.
Where is that? This is a contract relatable to 299 of the Constitution.
Well,
go to 299 of the Constitution. Your Constitution. Go to Article 299. 299. Kindly see that 299 also. Is it a contract in executive power of the state? You. Mr. Counsel, is it a contract relatable to 299 in the Constitution?
Well, I read that it says an exercise of the executive powers, but well, this contract, if you say it's a statutory contract, because this contract is provided under the statute, which is Form K.
Therefore, it is not in 299.
That I need to check, because in the agreement itself, it says Form K as per Rule 29, as per Rule 23A2 of the Act, the Irrigation Act that we placed earlier.
There is one view by which High Court I do not know. One view, because of Apex Court decision in Ram Javaya, what is executive power is defined. In Sahib Ram Javaya Kapoor versus State of Punjab, Justice B.K. Mukherjee's judgment. What is executive power of the state? What is legislative power of the state? What is judicial power of the state? Very old judgment, maybe 1950s, I do not remember correct year. We were taught in the law school. If it fits into that, then it goes to 200, whether it is under the statute or not.
Or not.
But one view of which High Court I do not remember. Where agreement? Have you that? Do you have that judgment? I was happy that he was going to assist me, but anyway, there, if the contract is entered into under statutes, then they are excluded from 299 is one view. Very old view, I am telling you. After my much I have not seen 299 after I left the compulsory college. Just I am asking. If it is 299, then various considerations arise.
This is under the statute, my lord.
Statute. Whether statutory contracts are excluded from the purview of 299 is the question. How DD Basu, CY, AP Tata, MP Paili, how they have viewed it. Even V.N. Shukla. Yeah, this Sahib Ram Javai Kapoor, 1955 Supreme Court. 549. The famous judgment.
It's a 1955 judgment. We've got it.
Their particular paragraph is there. I remember. Come to para 10. They have quoted the executive power of the Commonwealth is vested in the Queen and is exercised by the Governor General as the Queen's representative. The same they have said that. In addition to this, the King could assign other functions and powers to the Governor General under Section 2. So, go to 14. Para 14. Can you read it?
No.
It may not be possible to frame an exhaustive definition of what executive function means and implies. Certainly, the executive power connotes the residue of governmental functions that remain after legislative and judicial powers are taken away. The Indian Constitution has not indeed recognized the doctrine of separation of powers in its absolute rigidity, but the functions of the different parts of the branches of the government have been sufficiently differentiated, and consequently, it can very well be said that our Constitution does not contemplate assumptions that one organ or part of the state of functions that ascertainably essentially belong to another. The executive indeed can exercise the powers, but the function that power have to reduce also perhaps 14 supports his view that once it is a statutory contract, it goes out of 299.
Well, because the word says as your lordship was pointing out, the executive indeed can exercise the power of departmental or subordinate
statute.
Well,
the statute or subordinate legislation.
That's what I was saying.
Therefore, there appears to be.
That's why I said, when the form itself, when we see the agreement, it says on the top, Form K as per the statute.
Just some debate took place at the bar as to statutory contracts like the one at hand do not attract Article 299 rigor of just my examination. Well,
my lords, my lords, now I'll bring your lordship notice to Rule 23A, where the engineer has to act for different purposes.
Even under the contract?
My lord.
Please read.
My lord. Drawal of water from government water source. When any industrial, commercial or other establishment proposes to draw or lift water from a government water source, the executive engineer may earmark the bed and offshore lands of the said water source, free encumbrances, and set it apart for that purpose. There are a number of duties.
But this is post-contract. After the entering into a contract, he does all these things. But question is not that.
My lords, there are separate contracts for 3 years each. It is going on now also. It is such now. It is going on, my lord. Renewal. Yes, my lord. So the period 14 to 17, it is over. Again entered into another agreement for 17 to 20. In the meantime, supplementary agreement was reducing.
So the engineers have a role to play. If that is so,
my lord.
If that is so, why did you not act upon the recommendation of engineer in chief?
My lord, that actions should be under the rules and
by the government.
My lord.
Same answer will be applicable to other parts.
My lord.
For one, you cannot be selective.
No, my lord.
Engineers have a role to play if they are the persons who execute.
No, he has to either by the agreed conditions of the contract by both the parties, one has to act. Otherwise, by rule, where rule empowers somebody to do something, will act on that. That is my submission, my lord. And my submission is that the report, high-level report and audit report confirming that the source is a irrigation source was not challenged by the British.
Why he should challenge?
He has accepted rather.
No, why he should challenge? He believed that he will go by the contract.
My lord,
he believed in the principle, pacta sunt servanda.
My lord.
That government will go by the assurance given to me, contract with which I have entered into.
And another question was raised that they shifted the source from one place to another place for which there is a promise. There was no promise that if you shift the source from Virupa to Mahanadi, it will be charged differently. There is no promise. So question of estoppel doesn't arise.
Since it's a matter of contract,
my lord.
Once there is contract, estoppel is excluded.
My lord, my lord. And it normally should not operate against government. There are some judgments.
Not against government. It operates always against government also. And those are the judgments. No?
My lord.
That, which is that Motilal Padam
that, yes,
etc.
Yes.
Afghan, Indo-Afghan.
My lord, I have brought that judgment also. So, my lord, so far, refund is concerned.
No, your proposition.
My lord.
Estoppel does not operate against the government. Where is that perspective?
We have also referred to Motilal Malad. We have given the citation in a first note.
Given that?
We've given the reference. I've got a copy as well.
It is applicable. Both ways there is. It is applicable against government and there is some.
Yeah. Well, I've given a physical copy as well, man.
What happened in that Bhopal gas tragedy matter?
My lord.
Matter was before the New York District Court. And the Indian government took the position that Indian courts are better. Then Palkiwala's affidavit was filed there. Palkiwala and J.B. Dadachanchi, two lawyers filed affidavit before the New York court saying that our Indian judiciary is great because it recognizes and operates with the doctrine of estoppel and promissory estoppel. In that affidavit, they referred to Motilal Padam Pat. Bhupendra Bakshi's famous book, Law and Mass Disaster and Law. There these affidavits are produced. Long ago I am reading, I am telling you. I have referred to those affidavits in some of my judgments. Can you take out that judgment? Justice Krishna Dixit and Palkiwala's affidavit. Even in your, after I came here, here also I have made use of that affidavit. If that is so, how can you take up the contention? We rejected that contention in one service matter, wherein Mr. Lenka argued that there is no estoppel against the government. I could not find such proposition in any of the standard books on law of estoppel. There is no estoppel against law is another.
Yes, my lord. That is.
No estoppel against government is.
My lord, against law.
No, against law we can understand. But what is meant by law? Which is that law? CAG's report is not law.
My lord.
CAG's report is not law.
Law is that law of contract governs the conditions of the contract.
That's all.
That is law.
Then estoppel will not come.
Well. And that's what I humbly submit, my lord.
Yeah.
There is a pleading that they changed the source
from the statement with somebody, my colleagues have found out that judgment. This is Messrs. Shreshma Fine Chemicals Limited versus State of Karnataka and others. Report, what is that report, brother? Report. Yes. Get one copy of that judgment. I will put in my papers. Mr. Behra submits that doctrine of estoppel is not. Have you structured your pleadings on that ground? No.
On the estoppel, no, my lord. We have in fact, my lord, our contention is, as it fell from your lordships, that the fact on the reverse, the fact that they have made a demand on us in 2021, retrospectively from 2014 to 17 agreement and 17 to 20 agreement.
On the source of altered source of
altered source of water from water government source to irrigation source, which admittedly has been admitted by us post 2021 prospectively.
Separate agreement.
Right. So now, no, it was a supplementary agreement from the date.
Why do you say call it supplementary? Don't confuse me.
No, I'm sorry.
It's a separate agreement.
Separate agreement.
Yeah.
Separate agreement. I'm sorry. Now, my lord, we have made a contention that cannot be acceptable when they have rejected our claim for refund on the same ground that you had the terms of the contract are sacrosanct, it cannot be unilaterally reversed. So because you signed contract for 10 cubic of water, you cannot now say, please, because I did not use it beyond 6 cubic, you please return me my money. So if that be true, this cannot be true. So you cannot appropriate and reprobate at the same time. You cannot on one hand say that it is the contractual terms which.
And now hereafter coming that no, it should
very conveniently then reverse it. That's our main contention on which. And I'll also quickly counter the factual aspects.
Let us. Digital.
I'll your lordship
so well.
Notice that, my lord.
But how?
There is no change in circumstances.
No, you have changed the source.
Source was there from the beginning, my lord.
The source was there when Bhagirath brought water. Ganga.
No, my lord. No, my lord.
That's another thing.
My lord.
The question is, as on the date of the contract was concluded, you are altering the substract item of the contract. How could you alter?
My lord, that is why, my lord, from the beginning I have made it is.
No, I understand. No, I appreciate. That I want to know.
So
Because
for
any standard writers on law of contract, like Chitti on contract, like Cheshire Fifoot and contract, Hanson, they say it is not open to parties to the contract to alter the substratum. To make the contract.
My lords, I'm conscious of that. That is why, my lords, I made two different submissions for that. There are different things.
He is saying
My lord,
a government cannot act like a chameleon to change colors depending upon the season.
my lords, what I humbly submit, my lords, there is no change in the circumstances.
Correct.
In 2021, they accept it as a irrigation source, my lords.
21, all right.
My lord.
We need not travel to 21 at all.
My lord.
We should confine, whole thing is confined to 2014 to 17.
No, my lords. The 21 problem arose because of the audit report.
No, that is a separate contract.
My lord.
He is an industrialist.
My lord.
He does not want to be in court litigation.
My lord.
Therefore, he will make some arrangement. Many times we go that one. No? Why all headache? Instead of going to all these things.
In spite of that, they have challenged the things in separate writ petitions. They were withdrawn without any adjudication. So,
I am only asking. Once things are concluded in a contract,
my lord, it should be.
Pacta sunt servant.
My lord.
Whatever you have agreed,
My lord.
abide by it. That's the foundational principle of law of contract in all civilized jurisdictions.
You cannot go beyond.
You cannot go beyond. But contract is whatever you have agreed to that.
My lord.
Therefore, what you have agreed, you should abide by. That is how it is, like that. Otherwise, if ordinary people saying, I have agreed, but I have agreed to sell the land, but I will not sell it to you now, I can understand. But government having agreed, and if it goes back from its promise, then the people's faith in the governmental process is shaken. It is not case. It is not one case. That was the judgment of Apex Court. Maharaja, Rajadi Raja, so that which is that? The Scindia versus Union of India, previous case. Akivala's argument was that alone. Where you have assured all Maharajas that you are giving the privy first. Now, all of a sudden, if you say by executive order, no, hereafter we will not give. The faith of the people in the constitution and in the constitutional process will be shaken. Same thing happens here.
My lord, what I humbly submit. When
it is only a debate. I have not opinion.
When there is the defect come to the notice by of audit or anything, that should be the basis for
next contract.
Yes. Not the previous contract. When, my lords, I confine my arguments in clause 14. There is a clause for referring to the government. They have not availed that clause, so they cannot maintain a writ petition when there is alternative remedy available under the terms of the contract.
Any other ground? This is well. Yes, brother.
There's some factual issues. My lord,
no, first one.
My lord.
He said there is delay and latches.
Yes, your lord.
About 2 years plus.
Yes, your lord.
What is your explanation?
My lord, may kindly have para 31 and 32 of my writ petition. A statement has been made that para 32 and 31 and 32, page 15.
Saying,
my lord, may I read out, my lord?
Yeah.
May I quote para 31?
Give the gist of that.
My lord, this is simple. My lord, the rejection we had never received, which happened in 2019. We have taken that specific government, that 2019 rejection of refund was never communicated to us. In fact, not knowing that it has been rejected, we kept on writing letters.
When you came to?
In 2020. It is a specific that why, my lord, we came to know.
For the petitioner, admits that. Elaborate explanation is offered while paragraphs 31 and 32 of the petition to the effect that petitioner came to know of 15/3/2019 order at Annexure 26 only on 6/3/2020.
After knowing, we wrote 6/3/2020 letter.
You came to know on?
Well, that we have not said. What when we have stated that it was not communicated. Why it's letter after knowing we wrote them 6/3/2020 letter to reconsider. Well, can you see para 32?
That letter was sent to them.
Just before my learned senior answers, in the written objection in the counter, they have specifically replied to para 31 and 32, but it is completely silent about, as your lordship now is falling from your lordship, whether it was communicated and how it was communicated. I just wanted to bring it to your lordship notice that they have replied to para 31 and 32. I can take your lordship's my lord. Para 31 and 32 have been replied to in the counter, but no, it's completely silent on how they have communicated to us. Now they can.
How it was communicated? That letter was sent to the petitioner. How? Every day you say, na? There is no proof of sending the representation to the authorities. So now we are asking you from your vigilance.
My lords,
how it was communicated. Because they have taken up a contention that it was not communicated to us. How it was communicated? Who
my lords, I am just
on horseback or by auto rickshaw? What was the mode? (31, 32) first one. This court specifically asked learned EGA as to the mode of communication and the date on which it was communicated. Thomas, there is no explanation in that regard. Even that aspect is absent in the counter. Which is that paragraph?
Well, para 28 and 29 of the counter.
Paragraph 28, white paragraph 28 and 29. The counter. 29.
Well, hence my contention is.
But
yes, I'm sorry.
I'm sorry. Only you have to answer the points you got in the reply. You cannot re-argue the matter. Well, number 2. They had sent report of the High Power Committee and of the PAC. PH. What was your reply to them? How you have structured your stand?
My lord, in fact, when they, yes, your lordship, my lord, kindly have page 168, annexure 28.
Say,
my lord, what happened, my lord, after our allocation was reduced in 2018, they wrote to us again in 2020 saying that we have already reduced your quantity. However, now it has become, there is a committee report and the committee has decided that it will become a irrigation water source. So you please come execute a supplementary deed so the prices could be increased. Well, what we have said that we have asked for clarification, asked for copies of audit report and the high level committee, which is at Annexure 29 series.
They sent all that.
Yes, my lord. They had sent. First, my lord, first they said, please come and execute. We said, on what basis are you asking us to execute? Then, my lord, we asked them all the letters.
They
gave all the letters, my lord.
Then what was the version?
No, my lord, we accepted. It's a fact that we accepted that post 2021, you can increase it to.
Where is that?
No, my lord. My lord, may kindly have. My lord, may kindly have page 179.
Renewal agreement.
My lord.
No, what was the response to CAG report and the report of the high level committee?
My lord, our reply to that, my lord?
Yes.
My lord. My lord, may kindly have page 173. We wrote to them on 24 January 2020 that this is in reference wherein you had requested to provide us. We had requested to provide you a copy of audit report and high level committee for us to understand the sudden revision after 5 years to irrigation category and to put forth our views. Also requested for signing. While we were expecting above information,
You said you have not yet received a draft agreement information. We have not received.
My lord.
Then after receiving information, what did you say?
No, my lord. After receiving information, we provided that please give us a supplementary affidavit, to be fair, my lord, at page 175.
No, you said 175. Said you provide the information.
No, my lord. I completely bought it, my lord. We have also said, please give us the supplementary agreement.
Right.
They gave us the supplementary agreement and we accepted it, my lord. So we accepted the government water resource to the change from government water resource to irrigation source in 2020, my lord.
Read para 2.
My lord. In view of the above, we once again request you to provide us the said draft supplementary agreement mentioning therein the effective date of agreement along with other terms and conditions for our review before attending your office on 1/2/2020 for the above purpose. Well, this was on 29th January and the next page, 5th of February is when the revised agreement was signed.
Revised agreement, is it a novatio or fresh agreement?
Well, my humble submission is it is a, my lord, may kindly see, it is a supplementary agreement.
I am asking you the question.
Yes, my lord.
In law of contract, there is a concept like novatio.
My lord.
Whether that alters the parameters of your 14-17 agreement or it's a new agreement.
My lord, may I only clarify? There are 3 agreements in effect as we are talking about. One is from 14 to 17, 17 to 20. Now, my lord, 17 to 20 was expiring in August of 2020. My lord, may kindly note the date.
Correct.
My lord, may now come to 177. This supplementary agreement, which was executed in February of 2020, was till 3/8/2020. So it is not a fresh agreement as such, because fresh agreements are about 3-year period. That is why, my lord, I apologetically said, my lord, it's all supplementary agreement. 3 supplementary agreements.
My lords, this is like this, my lords. 17 contract subsists up to 2020, my lord.
Right.
Keeping all conditions.
17, no.
3 years.
I am asking you.
3 years.
14 to 17 is one agreement,
my lord.
which is the subject matter of dispute now.
My lord.
Then from 17 to 20, you have another agreement.
Another agreement. By supplementary agreement,
What is your
my lords, 1 minute. Keeping all conditions intact, the quantity was reduced. Only that part.
No, period.
Period, that is up to
shipment only.
No, my lord. It is only reducing the quantity. My humble submission, my lord.
Submission, all right. Since you are a lawyer, I have to put some questions of law and contract to you. standard writers, they have said there are judgments of Apex Court also. The Polak and Mullah, they say if effective date of the agreement is a fresh one, then it is a new agreement. Unless you say this agreement shall be treated as part and parcel of the first agreement.
My lord, so the language.
Then, yeah, language is very important. Law, entire law is in language.
My lord,
It does not sing.
your lordship sees the very heading of that agreement.
Supplementary.
Yes, your lordship. That's 176.
Keeping it.
Supplementary agreement to the supplementary agreement dated 26/2018.
Not to 2014 agreement.
No, my lord. There was no
14 to 17 agreement.
14 to 17 agreement, my lord.
It does not refer to.
Was not changed.
That is what I am asking you now.
It stayed how it is. Let me just, my lord, clarify factually. 14 to 17 stayed as it is. After executing for 14, we wrote to them in 15 saying, please reduce our allocation. 15, after our my lord, application was filed, engineer-in-chief recommended it. While it was coming to an end, the 14 agreement was coming to an end on 17. They allowed us, they informed us, yes, your reduction is allowed. Please come and execute.
No, that is for reduction is allowed under the same act. It is for the subsequent period.
Subsequent period, because it was ending. Correct.
Our all confusion arises because of the wrong usage of English language by your parties.
I'm sorry, madam.
Supplementary agreement is a concept. It's not just the English word, English term.
Madam.
What is supplementary agreement? There are judgments on that. Therefore, of course, anyway, we are not guided by the nomenclature of the document is there.
Madam. I am only trying to impress upon my lord. 14 to 17, there was no supplementary agreement to that effect.
In other words, this agreement is a standalone agreement. It's an independent agreement.
May I just clarify, my lord? Factually, because it's important.
Question is, it admits only binary answers. Yes or no, then you can explain.
No.
I am asking you. The problem is, should not say that.
I'm sorry, madam.
No, not like that. Because these questions are ignorant. The foundations of law of contract should be strong.
Lord,
otherwise, these problems arise.
My lord, this agreement only changed only one aspect of the previous agreement. All other terms remains constant. That is our case, my lord. Our case
not
is
only one. It changed sources of power. It changed quantum of supply.
No, my lord, it did not. That's what, my lord. My lord, kindly bear with me. Kindly bear with me for a moment. I think we have not factually clarified it. There was one agreement of 14 to 17.
Correct.
There was no change in that.
Correct.
We made a prayer for reduction. When it was coming to an end in 17, when a fresh agreement was to be executed, they said, come, we will execute the fresh agreement in a reduced quantity. That was discussed. Suddenly, 7 days before I have to sign my subsequent agreement for 3 years.
Agreement.
No, man, not supplementary agreement.
Subsequent agreement.
Subsequent agreement for another 3 years. 7 days before that, they withdrew that letter saying that no reduction. So, 17 also I signed for 10 cubic. Am I clear, my lord? No? Right.
That was the same quantity.
Same quantity. Same quantity, and it remained for government water source. Same money. In 18, while that 17 to 20 agreement is subsisting, they said, yes, we will now reduce it. The quantity. Now, my lord, may kindly note, 25/6/2018 is the first supplementary agreement through which they only reduce the quantity, the price, the rate, and the source remaining constant.
Source is government source.
Government water source, and the quantity came to 6, and the period of 3 years. Now the subsequent. So, my lord, why I'm saying this 25/6/2018 also, your lordship may kindly have a look so that it will clarify. 25/6/2018 is at page 135. We'll go step by step, my lord.
135.
Yes, my lord.
Yes.
My lord may kindly see, this says supplementary supply of water. My lord has it?
Yes.
Please come to my lord 137. Please my lord have the table.
Schedule.
The schedule. The schedule says 5.9 cubic, so it reduced it from 10 cubic. But my lord may kindly see the period of supply. Period of supply remains as the origin of 17 was till 3/8/2020. So this also says it is up to 3/8/2020. Correct? Now what happened, my lord? While this was continuing, what they did, they executed another supplementary agreement, which your lordship was now seeing at 176.
176.
Yes.
Yes.
Your lordships are correct. The usage of the term is
Ask him to go to 176. What is he doing?
176.
176.
And 30.
Ah.
Now, my lord, your lordships are absolutely correct. The terms are not happily worded. My lord may kindly see supplementary agreement to supplementary agreement at 25/6/28. So what they're basically saying, 2018, the reduced quantity of 5.98 will now be in a higher rate. So now it is irrigation water source. My lord may kindly see the schedule.
The source was changed.
That's correct, my lord. I completely bowed down. So now the source is changed.
Quantum is reduced.
Quantum is the same as it was in 2018.
2018.
Correct.
That is reduced quantum only.
Absolutely, man.
Source is changed.
Yes.
As a consequence, rate went high.
Absolutely, man.
That's the.
I completely bowed down. Now, my lord, why, my lord, my sequitur for this is, if you yourself executed several supplementary agreements, changing the quantity, changing the water source, hence the rate. So your ground of saying that your application of 2015 was not considered and your money will not be refunded back because the contract remains
saved.
The terms of the contract remain sacrosanct. You cannot take advantage of your own wrong. You sat over my application in 2015. You woke up from your slumber in 2018. You are now creating a case that I did not give you enough reasons.
Understand. Then what is your reply to why not you go to adjudication, arbitration?
Melon, I'll just take two things. Melon, first ground is, as the lordship is a judgment of Ram and Sham. Melon, I'll give
Ram Sham. I know that.
Melon, it's Caesar's to Caesar's wife. No appeal can be done from Caesar's to Caesar's wife. No, Melon.
But you have agreed to that.
No, Melon. I have
to go to Caesar's wife.
Correct, Melon. Yes. As your lordship knows, these are statutory contract. I do not have
this is not the statutory contract is one thing.
Melon.
You are not some some killers.
Well,
about the land, the laborer, peasant.
That I am not aware of.
You are an industry. You are an industrialist.
Correct, man. Now, my lord, the submission to that effect is, there's two submissions, my lord. The first limb of my argument is that agreement that you're talking about of 2014 to 17 and 17 to 20 has already expired, has already been performed. Now in 2021, you arbitrarily, unilaterally say that as per that agreement, you pay this amount. By that time, the agreement is already performed.
But dispute relating to the agreement remained.
That's correct, my lord. My lord may kindly see 14 to 17. In 2021, that period anyways has expired. They cannot raise any dispute on that period. My lord, for 40, because their demand now in 2021 is for 14-2020. It covers a 6-year period. Now, my lord, to say now, when counter has been filed, objection has been filed, all of hearing is at its completion stage, to say that now you to the government, where government has been party to this petition, my lord, they could very well say that this is, my lord, as your lordship kept on asking the question, how can you ask two things together? If you are asking that, you should concede on this. Now for this, my lord, I have to go back to the government again. It will not be efficacious, my lord.
My lord, your lordship's query regarding communication, my lord. My lords, kindly turn to page annexure 26.
Page number?
Page
155.
My lord. And
Dated 15/3/2019.
my lords, page 26, 126, 56, I think. The memo number is here and it was sent to INFA, the last one. And in very next page, they have referred to that memo, my lords, that letter. My lords.
31 July it was.
My lords.
This is 53.
15.3, my lords. His application for refund was rejected. Your lordship asked to know how it was communicated, my lords.
Sure.
My lords, the very next
Where was the
page.
reference?
Lords, the next page, very next page, my lords. It is letter dated 6/3/2020. My lords, reference the second letter, your order number 7742 dated 15/3/2019. It is not that they were not aware of the things.
No, when they came to know. That was on 6/3/2020 letter you are referring to.
That is what your lordship had noted.
My lords, in that letter, they have referred to that letter, my lords, 15/3.
Correct.
They have not stated that we have not received that.
No, earlier letter, they proceed on the assumption that they did not have knowledge of that at all. Earlier one, kindly see 31/7. Had they known, they would have made that reference in this letter only.
My lords,
He's saying,
my lords, what I humbly submit, my lords, in letter dated 6/3/2020, they refer to the letter dated 15/3/2019.
Correct.
It implies that they have received the same.
No, you
pursuant to the memo. It is page 156, memo number 7745, dated 15/3/2019, my lord. Copy forward to INFA.
The EGA draws attention of the court to petitioner's letter dated 6/3/2020 at annexure 27 series, which refers to that is dated 15/3/2019 order.
Yes, sir.
And therefore petitioners cannot feign ignorance. First one.
That is my contention in para 32.
Yeah.
That after I came to know, I wrote this letter.
Counsel for the petitioner submits that in the earlier letter correspondence, nowhere they have mentioned about the government order dated
15/3/2019.
Because they had no communication of that. First one. Immediately on coming to know of the same, they have made the subject representation, and therefore it cannot be inferred that the petitioners had knowledge even before that. No.
And the letter dated 15/3/2019 was annexed by the petitioner in his writ petition. And it was not stated anywhere the source how they got, if it is not communicated, how they could possess the letter. The inference should be that they have...
They received it in time. Mr. Behera submits that in the fitness of things, government should be presumed to have discharged its duty diligently. And since petitioners had replied to the subject letter, referred to subject letter, it is for them to specifically state as to how and when they received the said letter.
In absence that, it will be presumed that they have government communication.
In the absence of that, presumption is that the government had sent the letter immediately after it was prepared. Okay.
I don't reiterate, but your lordship has already recorded that we have stated it in para 3132 not been objected.
But once you received the letter, you should say who brought the letter to you, which postman brought the letter to you, in what form, what was the envelope. That your duty it is.
My lord, with all due respect, my lord, we have submitted it by saying
if
clearly.
you had not received at all,
My lord.
then it is their duty.
My lord.
Once you receive, the courts have taken the view in law of notices by Majumdar, A.B. Majumdar. He has referred to this. Once you receive the notice, you should say when and how you received the notice.
My lord, I have not received the notice.
No, please, you would not have referred to that.
No, my lord, that's my contention. My lord, may kindly see para 32. I have clearly stated that I did not receive the notice sent by them. When I went, that is what I'm saying, because I kept on writing to them about please consider my refund. I was told by them that you have already been rejected.
No, but you have then you have referred to that letter.
In 6.3, that is what I'm saying, my lord.
6.3.
My lord, in July 2019, when I kept on writing letters, in July,
all right, anyway.
I
But
kept.
at least when you came to know of that letter,
My lord.
when that letter reached your hand.
That is what I said. As soon as it reached the letter, I wrote 6.3. That is what my contention in para 30.
How it reached
32. No, that is what I've said. Well, in para 32, I have said that I did not know. I kept on writing letters that please consider. Otherwise, my lord, why would I write the right letters? My lord, it is very.
No, 32, just you read that.
My lord.
32.
My lord.
Being unaware of the order of rejection of refund, petitioner again wrote to the opposite parties wide letter dated 31/7/2019.
My lord.
Subsequently, petitioner learnt about the order of rejection and void its letter dated 6/3/2020, requested for reconsideration of its prayer for refund of the excess amount. Without knowing the contents of the letter, without having a copy thereof.
No, that's no,
how will you request? Nowhere you are stated. Even today, I don't have copy of the letter. You are not sending it to me. If you send that letter, I will take my action.
No, I could have done that as well, my lord, but I have stated clearly that subsequently petitioner learnt about that letter of rejection and vide its letter dated 6/3/2020 requested for reconsideration of the prayer of refund.
Correct. How will you request for reconsideration without having copy of the letter with you?
Well, I have said that I have learnt about that letter.
No, that if some teacher had said that, we would have agreed.
No, my lord.
Your company, it's a huge company.
No, my lord, I completely
having legal advisors.
No, my lord, I completely agree. That is why I have said that when I kept on writing letters, no, my lord, this has remained uncontroverted by them in their counter. They don't even reply to it. They don't even say that it is a memo, you have received it on this date. And my lord, now they say it should be considered that I have received it when I made direct statements to that regard, my lord. That's my humble contention, my lord. I have made direct contention that I learnt about it, and as soon as I learnt it, I wrote to them.
Yes, anything more to be stated?
No, my lord. I'm sorry, my only thing is, my lord, again, my lord, the same appropriate reprobate. If they are saying about delay in latches on my part to come and allege or challenge this rejection, because this rejection has happened in 2019, and I have filed this writ petition, my lord, I have challenged this in the year 2021. Now, my lord, if on one hand, assuming for a sake of argument is that is true, it's delay in latches. Now, my lord, their demand of 2021 for the year from 14 to 20.
20. No, 14 to 17 it will.
No, my lord, 14.
It has been saying 20 you have agreed to give.
Yes, my lord. Till that period. From that period, my lord, when the supplementary agreement happened from 2020, I paid irrigation water source.
Correct.
Which is more money. Now then, because I said so, they have now demanded that for two other previous agreements of 14 to 17 and 17 to 20, you please pay. Now, my lord, how can that stand? My lord, the same argument, there has to be a one touchstone for both the parties, my lord.
That is.
So there has to be delay in latches for them for the demand.
My last submission would be, the payments were made without any protest. Hence, as per section 63 of the Contract Act, there is accordant satisfaction. They have not entitled to any refund. My submission may be.
You can submit all right, but you have one more submission. Read section 72 of the contract.
That is breach and damages.
No.
72.
Amount paid in ignorance of law or fact.
My lord,
Where do you see that?
72.
Considered by the apex court in Mafatlal Industries versus Union of India.
Yes, my lord.
97 or 98 Supreme Court. Go to section 71, 72. I do not remember.
72, my lords, for breach, damages for breach, my lords. Hearing party is
73.
my lord. Compensation for loss.
No, there is one section.
My lord.
Amount paid in ignorance of law in English law.
Mistake, my lord,
72.
By mistake or question.
Mistake of not only the apex court said, in fact, in English law, whatever you do in ignorance of law, you cannot have redress because they are very strict in that every citizen is bound to law. Or Tolson, etc. But in Indian law, mistake of law is treated as giving a correct cause of action. Suppose in ignorance of law, I make more payment of tax. I'm entitled to refund. That is the Mafatlal industry, 1996 or 97 Supreme Court, SCR. Go to the Mafatlal. Mafatlal Industries, which is that Mafatlal. Go to 1996.
Very lengthy judgment.
Justice, I have
1996 Supreme Court.
Correct. 96 Supreme Court. Which is that paragraph? Money paid in ignorance of law can be recovered from the government, except where doctrine of unjust enrichment is involved. And Supreme. AR 1997 SC 506. So go to that paragraph, particular paragraph. Money paid in excess. Mafatlal Industries referred to. Money paid in ignorance of law.
Well, law is fairly settled that money paid under a mistake or on a consideration which has wholly failed or under duress falls under the general head of money had and received. An action for money had and received is an action founded on simple contract, which has been called quasi-contract and restitution. But they have also gone into the law, as your lordship says, of England, America, and Australia.
Yeah, that's what I read. That
where they said dealing with the plea that the position in law obtaining in England, America, and Australia that money paid under mistake of law could not be recovered.
Correct.
And that similar.
We have not agreed.
And then the court says observed in they refer to Kanhaiyalal's case.
Kanhaiyalal's.
Well, they said that court observed in page 16344 that the money, the recovery of money paid under mistake of law and fact can be recovered.
Which is that paragraph?
What I'm seeing is doesn't have paragraph. I'll just give you
paragraph. Yes.
I'll just give you the paragraph.
Paid in ignorance of Mafatlal.
It should be paragraph 14 as I see it, but I'll just
no, not
exactly say.
I'll find out.
Exactly say.
Just I wanted to know that. Anyway, both of you, even parties are argued very well. Very pleasant arguments. Well, let us see. What God dictation, God will give me the dictation, I will dictate it to my stenos. Yes.
That's why very deeply obliged.
It was a learning experience to me.
For us as well. We went through all that. We never knew about Nova Cosa, intervenience and all that.
No issue is treated by standard books on law of contract. They were treated.
When we checked up those two maxims, the three hits that came out was your lordship's judgment, one of Karnataka High Court, the second of Karnataka High Court, where your lordships has dealt with medical negligence case, and the third was here murdered of an environmental case of Odisha High Court. So those are the three hits which came in here. The other ones were of England. So we had to check up all those judgments. Deeply obliged.
Thank you so much. Yeah. We have one more day to work. or half a day to work tomorrow. Yes.
Item 43.
I have filed a petition for intervention in this case. What happened is that there is an interim order. There is a selection for the post of undergraduate teacher arts and Korea.
The petitioner.
And now we are the selected. We have passed the preliminary examination. This petition after vacation. No. What my intervention I'm just placing. The petitioner has participated in the process of selection when he failed in the preliminary examination, and the next exam is the main examination conducted by my friend's client. At that juncture, he has come and challenged that the entire process is wrong. But we are now unable to appeal the written examination. So far, the other subjects are concerned. Now the process is over. They are now going to be appointed. So we are now halted at that because there is a stay order. For one person, my lord, entire 700-800 post has been blocked. So this is my
order, your
where
lordship
the
has-
affected were selected.
Last order, your lordship directed to statement to file the counter
Yes, sir.
application.
I am now
The
affected.
counter application has
person.
not been filed, your lordship.
So my application may be considered first.
Only instruction can supply the problem.
They have filed it.
But in this case, my lord, in fact, I am appearing for the staff selection commission. 8 categories of the post, my lord, which are advertised in a common advertisement. And when dealing with 2 more post, my lord, that is TGT PCM and TGT CBZ. Just day before yesterday, before your lordship, that my directed that the commission of the result. Here, my lord, in this case, my lord, though this is also one of the subject. These are the TGT OA and the TGT arts, my lord. These are in the same advertisement, but are not in the process to move ahead because there is an interim order which is in operation.
Only for one.
In that order, we said wherever there is no interim order.
Yes, that is what. And my lord, our submission in this case is that, my lord. In fact, only 2 points have been challenged in this case. That whether a separate select list is to be prepared or a same select or one select list is to be prepared. That is the only point. And our sole submission is that, my lord, that condition is stipulated in the advertisement. The petitioner applied in terms of the advertisement, participated in the selection process. Now even if, my lord, hasn't did, he is not disputing that condition.
That part is not.
Milord, what happened in the case?
The particular list now is the
No, what happened in the case, Milord? I have to submit.
Sit down. Sit down. Sit down, Mr.
First, there is an advertisement for recruitment of TGT arts. Later, one correspondence was published, which reduced 25% out of the TGT arts seat and published separate seats for TGT Odia. But when there is a preliminary examination, Milord, in between, the OS, the recruitment agency allowed a student who is eligible to give 2 options. One is TGT arts and one is
heard this matter substantially. I'm just recollecting. I know my lord's memory is very sharp.
No, it's not that way. Now he is playing trick with me.
Well, no. Well, here what had happened, they advertised the certain seats that your lordship can see from the advertisement.
We will have it on 9th.
Yes, my lord, I will also file an objection to their intervention because they are not necessary parties to be added.
That's all. But suppose if their
Our right has been assumed.
they may not be necessary parties, but they are entitled to address when they are affected. On the ground that you have not made them parties, it cannot be dismissed as true. But they are entitled to ventilate their view because their apple cart is being upset.
My lord, I'll just file an objection. It let it be a 9th, my lord. I'll file an objection. Your lordship may hear it.
17.
I filed it from 25/8/25, my lord. 1 month before I have given him a copy.
On that, we post on 9th. Let us see.
Interim order to continue.
If you want to continue till 9th.
Well, grateful.
But if haven't participated in
Yes.
proceedings, you quoted that judgment another way is anyway.
Now, your lordship will now decide whether in view of that judgment, I have a case before your lordship.
That's
That yesterday's matter, my lord, because my lord is to rise now, that I am to give the dates only because Mr. Patnaik is there. That student matter, my lord, yesterday, my lord rise at that purport, only asked me to, when he has applied for that previous year, I carried it tomorrow. That boy is to take admission.
Many cases are moved today. the last working day. Tomorrow you have put up reference also.
That is first of all only 1 minute it will take. Yesterday my lord has come tomorrow. This is the only affidavit I am giving it. Have the dates only.
Tomorrow.
Lordship.
At 55.
You give it tomorrow.
55.
Question tomorrow.
Lordship, item 57, I don't mention, my lord. Item 57, taken up tomorrow. In press redemption, my lord.
What is that matter?
Matter, my lord, we are the dealers of explosive materials, my lord. The state government, when the gazette notification, the prohibited for manufacture or possession of
We'll
the
have it immediately on the reopening day.
in press redemption, my lord. In press redemption.
Put it on. My lord,
Item 56, my lord.
Since 92, this has been on the last occasion, Lordship specifical directory, if counter is not filed by today, then it shall be taken up on its own merit on the basis of the writ.
We may do it on the next day.
On next day, Lordship, Lordship keep it on a reopening day, 8th or 9th.
If reopening day, what? How?
The 9th, Lordship.
Suppose for any reason, but the bench, what that judge will tell me. Because therefore, we will have it on 16.
My lord, item number 56, my lord. Item number 56, my lord. That intervention, item number 56, my lord. Your lordship order has not been complied by the executive. The lordship passed the specific direction not to engage temporary guest faculty to the existing post, but violating the lordship order, the party engage one guest faculty basis. Even if your lordship specific order not to engage
This allegation is completely baseless, my lord.
Anyway, we'll have it on 16th. We'll continue.
Kindly continue.
Wherever there is interim order, just. We are praying. 60. All the three matters, 60 statutory of which man you know. 60 statutory of which appeals there. Right. Issue.
Yesterday I have mentioned file a government circular manner. Rehabilitation assistance scheme manner.
We'll see after vacation.
My lord, Hon'Ble, 56 may kindly be taken up tomorrow, my lord.
No.
56, my lord.
Who are that?
After death of his father, my lord.
It will come after vacation.
9th year, Lordship. Urgency, there are crore of officers like going to be damages, Lordship. It's a very small matter required to dispose of only hardly 5 minutes, Lordship.
Everybody says 5 minutes only.
Correct, Lordship. My opposite body counsel is there, Lordship. Only required to be 5 minutes disposal.
It is like saying to swallow the rasgulla. Rasgulla. One needs 1 minute, but all depends upon the health condition, size of the rasgulla. So many things are involved. I have said no.
Judiciary.
Everything's violated. Therefore, we have to take action.
52.
We cannot do tomorrow.
Fix up a date, my lord. 52, my lord.
52.
My lord, 10th, my lord. 52. Rehabilitation assistance scheme.
10th we have already
54
posted.
a day.
16.
54 a day.
54 or 23rd.
54 years.
23rd.
9th year.
19th.
No, 9th year, sir.
9th not possible, but it's a full, calendar will fall down because of the weight.
What else, Lord? Make my calendar schedule 14 years.
14. 14. Yes. Wherever interim order, thank you. Okay?